Check 1 2.
Can you still hear me okay?
Good afternoon, everybody, and welcome to the City Commission Conference Meeting this October 7th, 2025. A little housekeeping here. I think, all right, is there any way we can turn down this? The mic seems a little, like I'm getting a little too much feedback. Okay, all right. So we have some interesting topics to talk about this afternoon, and I see where Commissioner Sorensen is appearing by Zoom. So, hello, Commissioner.
Hey, Mayor. Thank you.
Can't hear you.
Check 1 2. Can you hear me?
No.
How about
talking.
now?
Yeah,
Yep.
we can hear you now.
Now you got me. Great. Thank you.
Very good. Okay. So the first item of business that we have is Business 1. This is the City Hall update, and I want to start the conversation and asking our city manager to please begin the discussion.
Thank you, Mayor. Good afternoon. Today we'll have a presentation by Jacobs, the city's owner's rep, to introduce us. Ben Rogers, Assistant City Manager, will come to the podium. You should have received this morning some updated information on this item, and Ben will go over those updates in addition to Jacobs. Thank you.
Okay. And Ben.
Good afternoon, Mayor and Commission. Ben Rogers, Assistant City Manager. As the City Manager indicated, we've onboarded Jacobs over the summer to be the owner's rep for the project. That is a task-based contract, and the first task order that we did with Jacobs was to help us with the review of these initial unsolicited proposals. So I've got Jonathan Jordan and Alan Cohen of part of the project team. They're going to come up today and talk about their process they went through, how they determined the criteria, what they looked for in the proposals, and the outcome of the proposals.
Okay, so today Jacobs has submitted its report. You want to go over that? Are they here? Oh, they're here. Very good. Mr. Cohen, haven't seen you in a while.
Yes, sir.
Good afternoon. I'm Jonathan Jordan with Jacobs. This is Alan Cohen, who most of you know. I want to thank you for having us here today to present to you.
Can you kind of speak into the microphone?
Sure. Thank you for having us here today to present to you on our process and our findings as part of the evaluation of the unsolicited proposals for your future City Hall project. This is the agenda of what we'll be going through today. I'm not going to mention each one, but just to summarize. So, where are we today? How do we get here? On May 15th, the city received an unsolicited proposal from Fort Lauderdale Civic Partners and then issued a notice indicating that other firms that wanted to submit competing proposals could do so over a 60-day period. And August 5th, the city received 5 additional proposals, and Fort Lauderdale Civic Partners actually revised theirs and resubmitted it along with the other 5. So you have 6 proposals that we evaluated as part of our role. And the city issued us task order number 1 to start that process on September 3rd. And part of that was to include developing preliminary criteria, conducting initial evaluation, and then presenting the findings to the commission, which brings us here today. So the developer teams that proposals were received for, as you can see from the slide, the lead developer for each team, Balfour Beatty, Cypress West LLC. Gil Bain was a developer as part of the Fort Lauderdale Beacon Collaborative. Plenary Americas was the...
The rest of the teams have a variety of members to them. Industry Developments is an all-local team. We didn't have much other information in Cypress West until just a few days ago. You'll see a note on the file here that they notified us that they've added CAST as their general contractor. The other 4 developers have a variety of local and international firms filling out their team. This slide just gives you an overview of the different firms. You have 2 small locally owned firms and 4 quite large, either national or even international firms. Those 4 firms have extensive experience with P3s and with large complex projects. And next slide, please. Okay, here's the evaluation criteria, and we're going to spend a few minutes on this slide to give you, you and the listening audience, a better understanding of how we got here. So all but one of the criteria that you're looking at are what we call developer-centric. The developer is the entity or individual that is responsible for delivering a successful project to you. They're the one you're going to sign an agreement with. So we took a look at the developer and their experience and capacity. The one exception to this is the first column, which is key personnel, and we looked at all of the professional personnel for the architect, engineers, general contractor, and the development team as well. The first column is primarily to address a requirement in the P3 statute that you also comply with what is called CCNA, or the Consultants Competitive Negotiations Act. and you look at the qualifications and experience of professional personnel. So we took a more comprehensive look at the teams for that. Moving on to the other criteria, again, we looked at the developer. The first column, City Hall or Government Center. To clarify, a government center is a city hall in another name. The Aventura City Hall is called the Aventura Government Center. It's the place where government is headquartered, where administration lives, and where the legislative body meets. Broward County also operates in the Broward County Government Center. So that was the first criteria, but we also recognize that not everybody would have had the opportunity to work on a City Hall project, and so we added two other what we felt were relevant criteria. The first were municipal projects, where we wanted to assess the experience of the developer in working with local jurisdictions and delivering successful projects. With the office building, given the nature of this project, the site that we're located in, it's going to be a multi-story specialized office building. And we wanted to see what experience the developer had in delivering a similar type project. This is the next column, P3. This is a P3 process. So we wanted to understand the experience of each of the developers in leading and delivering P3 projects. References, pretty straightforward. We asked the developers for examples of work that they've done in the past to fill in those other columns that I just spoke about. P3, City Hall, municipal projects. We called every one and got through the most of them, and we'll talk more about that in a few minutes. Developer financial capacity. This was taking an initial look at whether or not the developer had adequate financial resources. And when I say initial look, we didn't do a deep dive on this one. In the next step, we'll be looking at financial statements and the like. This was more of a cursory review, looking at Dun & Bradstreet information primarily. Developer litigation history. We were looking for essentially red flags that might be a cause for concern. Are there conflicts? Are there situations that might impact their ability to successfully deliver the City Hall project? And lastly, the P3 statute compliance. 255065 is pretty specific in what needs to be included in an unsolicited proposal. So we looked at that, and we looked at other aspects of the statute as well to see if the developers were compliant. Next slide, please. So this slide is more for the benefit of the commission and not the review team. Our review was a pass-fail review, but we wanted to provide you just our thoughts on what we thought were primary criteria and secondary. Secondary does not mean they're not important. As I just explained with City Hall, municipal, and office buildings, they're all interrelated, and they should be treated as such. Had we had our druthers, financial capacity might have been a primary criteria, but as I said, because we did a cursory review on that one, we didn't feel it was enough of a review to merit being primary criteria at this time. It should be absolutely moving forward. Litigation history, we only looked at current litigation. We didn't look at past litigation, and we think that litigation history for all team members should be looked at for shortlisted teams. Next slide, please. Okay, got it.
So this was a first criteria for key personnel, and as part of that, we evaluated the developers, personnel, and all their team members as well. And they supplied us with resumes for all their key people. And we evaluated that, and what we were looking for was the professional qualifications and experience on large, complex projects, because we view the City Hall project as large and complex, and we thought that was very important. So as you can see at the halfway through the slide, we indicate which firms met or didn't meet that criteria based upon what was submitted and our review and evaluation of that.
So yes, you skipped one. It's okay. You can go back. So the previous slide there we go. Regarding City Hall experience, only one of the developers has actually delivered a City Hall project. The other five and let me clarify something. Our review was based on the information provided. We looked at the proposals, we looked at the supplemental information that we requested, and based on that, we looked to see whether or not the developer led and delivered City Hall project or the other relevant projects that we'll be talking about momentarily.
Could I jump in on that real fast? So I'd like to make this a sort of an iterative conversation. So we've got teams here, right? So you're saying that if one of the team members has experience doing that, but the developer, the primary developer, does not, you discounted that. Is that my understanding?
I wouldn't use the language discounted, Commissioner, but
Okay.
we only looked at the developer when making these criteria determinations. Yes.
Okay. Because I kind of thought that's the whole part of having a team, is that you've got people with different qualifications that they bring to the team. Not everybody needs to have done every aspect of that project. But okay, thank you. At least I understand the project process.
And I'll point out, Commissioner, that again, we did look at the entire team for their general qualifications and experience. When it came to these other individual criteria, that's when we focused on the developer as the person responsible to you.
This next criteria was for municipal buildings, and all but one of the teams met that criteria, as you can see from what's on the slide.
Office building experience, as you see, 5 of the 6 developers had experience delivering an office building project. And we had 4 of the 6 that had experience delivering a P3 project. Okay. Regarding references, as I told you, we spoke to a whole lot of people. Everyone was positive, and all of the developers met this criteria.
So all the firms provided some information on their financials, but not full financial statements. So we used Dun & Bradstreet reports and gleaned whatever we could from those, and to do some sort of an evaluation on what the financial strength was. But at the next evaluation, there needs to be a deeper dive on that. But based upon what available information was available to us, we found that all but one firm met that criteria.
Just a quick question. Dun & Bradstreet, don't they basically get their information from the party who they're analyzing? They don't have any independent information. So when you say we're relying on Dun & Bradstreet, we're relying on whatever that particular company has provided Dun & Bradstreet as being the basis for their financial worthiness. Is that correct?
That's correct.
Okay. Thank you.
Litigation history, we also relied on the developers indicating to us whether or not they had any current litigation, and no one indicated as such. They all met this criteria.
Well, that's not true.
Yeah.
FTL Beacon Collaborative, one of its partners is EDSA, and we're currently suing them.
And that this was, Mayor, again, a developer-centric criteria, so we only looked
Well, they're
at...
part of the team,
I understand that, sir.
so we can't overlook that.
And we are encouraging you to ask for litigation history for all the team members in the next phase of your review.
Okay, thank you.
Next was P3 statute compliance. as I have already stated, the statute has certain requirements. After review, we deemed 5 of the 6 developers to be compliant with the P3, the Florida P3 statute.
So this slide is the matrix where we basically summarized all the firms, all the criteria, who met and who didn't meet. And across the bottom is a summary of each firm and of the 9 criteria, how each firm did against the 9 criteria.
Okay, we'll switch off. All right, so we prepared some additional slides just to give you what we felt was some relevant information, including local projects and just notable or noteworthy factoids about each of the development teams. We'll point out for Balfour that they're completing the $1.3 billion Broward County Convention Center and Hotel project right here in Fort Lauderdale.
Cypress West is a firm that I think we're all familiar with. In fact, the city is leasing space from them right now at the Fort Lauderdale Landings campus.
Beacon Collaborative, we didn't specifically have information on local projects, but they've been operating in Florida for 53 years. They were established in 1870. This is actually, interestingly enough, a family-owned business, still owned by the same family from 1870. And their partner, Gilbane is the lead developer, but they are partnering with Fengate as a major equity investor in the project.
And Fort Lauderdale City Hall Partners, being led by Plenary, and of course, part of their team is Stiles, and of course, I think everyone is familiar with Stiles. They've developed numerous Class A high-rise office buildings here in downtown Fort Lauderdale.
Civic Partners is led by Meridian, and they're quite well known for leading the Port Miami Tunnel, which is an internationally known P3 project that they successfully delivered on time and on budget.
Under budget.
And Industry One Developments, their team highlights are their, as they stated, were their proximity to the project site, their longstanding community ties, and a portfolio of civic and global infrastructure projects. This slide summarizes the results from the matrix that we showed a little earlier. So of the 6 proposals, it was found that 1 firm met all the criteria, or 100%, which was Fort Lauderdale City Hall Partners. 3 firms met all but 1 of the criteria: Balfour Beatty, Fort Lauderdale Beacon Collaborative, and Fort Lauderdale Civic Partners, which works out to about 89%. 1 firm met 5 out of the 9 criteria, Cypress West, and 1 firm met 3 out of the 9 criteria, which was Industry One Developments. So thank you for the time to present. If you have questions, we gladly will entertain them.
Well, great, thank you. It's very helpful as we move forward on this process. Does anyone from the City Commission have any questions of these gentlemen? Ben?
Thanks, Mayor. I'm good for right now. Thank you.
Okay, very good.
So Mayor, not a question, just an overall comment about the process.
Yeah, go ahead.
I wish we had had more of an opportunity to discuss this weighting criteria. I know I've talked to a lot of the folks who are proposing, and they were kind of surprised by some of the conclusions that were arrived at. And I think this is reflective of the fact that we really haven't been very communicative about the process to the developer community. I think we could have done a much better job. I certainly would have liked to have had some input onto how these were evaluated. I'm not sure I agree entirely with what was done. So I just really think we could have done a better job in the process.
Okay. Any other comments or questions?
I'd like to at least start the conversation of where we'd like to go from here? Because I personally believe that we should hear four presentations going forward.
All right, so a number of people signed up to speak, most of which are just the developers. I don't know whether this is the time to be having that conversation.
Mayor, I don't think we should go through presentation summarizing.
Yes.
The staff is recommending that 4 of the 6 firms be shortlisted to advance to the next phase of the evaluation process based on what Jacobs presented today.
All right, so Jacobs, first of all, thank you for your work. We appreciate the time and effort you put into it. I know you folks are very experienced in this, and you're providing objective criteria in terms of the evaluation makes it more transparent for everybody to understand your conclusions and how you arrived at your conclusions. With regard to the results, I think that saying, well, there's only one that qualified 100%, I think listening to the city manager, we should probably expand that and take the top 4, which at least gives the city quite a few more options to examine more deeply what the qualifications are of these people. I know personally, I'd hate to disqualify somebody because of one criteria that wasn't met, especially since I think this is a 30,000-foot examination of these applicants, and we now need to get more ground level and see and dig more deeply into what the qualifications are and the expectations of the city. So,
Mayor?
Yes, sir.
If we're going to be considering cutting some of the potential developers out of the process, I really think we ought to at least give them the courtesy of letting them present. I mean, a lot of these folks have spent significant amount of time, effort, and money putting this together, and candidly, I'd like to hear from them before we make that decision as to what we're moving forward to. We're going to be living with this for the next 50 to 75 years. I'd like a really full, robust discussion. If it's not today, then I think we should schedule it for another time, but I really would like to hear from all the presenters.
Well, we will.
Mayor, can I jump in?
Yeah, go ahead.
Thanks. So this is, our at previous commission meeting, we had a great discussion about the process here and what the process would be. And we all agreed to that process, which I think is a great process for us to be following. And that process that we all agreed on was that today we would shortlist, we would eliminate some of the applicants, and that would be a smaller list. We agreed that there wouldn't be any presentations today, and we agreed that when we would next convene after staff did a further deeper analysis of the remaining firms, at that point there'd be presentations, short presentations from the applicants. So I think, let's stick with the process that we've agreed on. And I think the next step after we narrow the list here today is, and Ben Rogers and Raquel can maybe it'd be helpful for them to speak to this now. But my understanding is that there's going to be a more robust analysis with the firm that's going to help with that. This PFM, I believe, Mayor, is going to be part of the process to take a deeper dive. And then what we talked about was that on or around December 2nd, the remaining firms would present at that point. So I agree with Mayor what you're saying about 4. 4 makes a lot of sense. And so I just share, I think that's the right process to kind of continue on.
Okay.
I just want to correct the record, though, Commissioner Sorensen. I did not agree to the scoring criteria. So let's please not say that it was unanimous, because I did not. Thank you.
Okay.
Vice Mayor, sure. I said process. We all agreed to the process of what would happen, what date.
Sure. The process includes the criteria by which we are evaluating them. And that's why I'm saying, had I had more of an opportunity to see what the evaluation criteria was, I think it would have been helpful to me. But leaving that aside.
Great. Yeah. No, that's fine. And that's actually a great point, Mayor. Because here's what I'd suggest
wait, Ben, before you go any further,
yeah.
I want every member of this commission to know that if they have some suggestions or they have their own experience that they'd like to share with Jacobs, no one is preventing any member of this commission from picking up the phone or emailing these folks and getting a better understanding of what the criteria are, or getting a better understanding of the approach that they're taking in order to evaluate these applicants. So it doesn't always have to happen here in a commission meeting. The only thing that has to happen here in a commission meeting is the exchange of ideas between commissioners. But if you have any suggestion, if you have any suggestions to these folks, you're fully entitled to speak with them.
Mayor, I would respectfully disagree with that. I don't want to be the one lobbying Jacobs as to what the criteria would be. I don't think that's transparent. I think it needs to be a consensus of all of us. I do think it needs to be something that we discuss here in public. I don't want to be calling up Jacobs and saying, well, here's my opinion about what I think is the appropriate design criteria without the input from everybody else. We could disagree, as we often do. So I wouldn't want to be the one trying to drive that outcome all by myself. But again, we disagree.
Well, is there something you'd like to suggest today then, or do you want to wait for the
my
next meeting?
suggestion, which I think I was fairly reasonable about, is just to say I think we ought to give everybody an opportunity to present. I'm not suggesting that we don't go with narrowing this down to 4 or anything else. I'm fine with that aspect of it at this point. I don't want to slow this down unnecessarily. But again, I think in deference to the effort that everybody has put into this, I think it's worthwhile hearing what everybody has to say. But that's my opinion. If we don't agree, we don't agree. That's fine.
All right. So why don't we agree to now narrow it down to the 4, and at a future meeting we will allow folks to present and make their presentation and give them enough time to be able to make their pitch to the commission. I think that's always been I think that's always been in the plan. We're not going to deny people the right to speak. It's just that this wasn't the meeting that we had intended for that to happen.
I just want to be clear on this, though, Mayor. You're saying how many, are we narrowing down the number of presentations at the next meeting?
If we narrow it down to 4, those would be the 4 people.
I just want to make sure it was a little unclear what you were saying. I wanted to make sure that that's what we were doing. We're not, because you said that everyone's welcome to present and speak, but I do believe that we need to narrow the presentations to 4 presentations.
But it doesn't prevent anyone else from speaking regard to on their own behalf.
Of course, but not a 20-minute presentation.
No, I'm not saying that.
They would have 3 minutes to speak.
Or whatever, yeah.
Or whatever, or 2. Okay.
So Mayor, we can go through what we anticipate to be the next steps, but we are looking at December 2nd as the date that those 4 shortlisted firms would be able to present.
Okay.
And then on December 16th, we're looking for authorization for me to begin negotiations with the selected firm. I'm going to ask Ben Rogers to come back up to talk about some of the steps that we would need to go through before that December 2nd date that would allow us to have a thorough discussion.
Okay, Ben.
So, Mayor, the IT team is bringing up a slide just to help with the illustration of the timeline. There's really 4 next steps that we're looking at and categorized in buckets. The first one is shortlisting, which we're hearing the commission will be doing today. And staff will be working on refining the scope of the building. So we're going to, as we talked about in the previous meetings, we're going to dust off the old documents. We're going to get the right square footage. We're going to define the amenities for the building, what the commission chambers look like, and all the other specialty elements of the building. We're hoping to have that process completed by mid to end of next week. And then we would be releasing that information to the shortlisted proposers to have them respond with updated information. We also are working with PFM, which was indicated earlier, who will be doing the financial analysis once the responses come in. So we'll incorporate any questions or information that PFM needs as part of their response at the same time they release this square footage and amenity package.
So if once that's released and once the applicants have a much better understanding of our needs, then can we expect them at the December meeting to be able to provide a cost estimate of the building based on all the criteria that have now been established by that time?
So we're going to be asking them for their cost information based off of the information we provide. That way it's apples to apples on the square footage and the amenities and what the building will look and feel like. Obviously, once we move forward and we get into negotiations and we start getting into design elements, I think that's when your real cost will be brought forward. But we are going to be onboarding PFM to do a check of the information that they provide to make sure that it is in alignment with the downtown market, what the construction costs are that they're putting in their proposal responses, to make sure it's accurate, and then they'll be identifying any challenges, concerns that they would have with that information. So that way in December, the commission has a number tied to our current standards or current space needs that has been reviewed by someone to make sure that the pricing is consistent with industry standards.
Got it. Great. Yes, go ahead.
Mayor, if I may, and just help me understand why we need another 2 months for this to happen. Why it seems a little long, but help me understand why we need to wait another 2 months before we're able to come back and do some more work on this.
Yep. So for number one, we're trying to get it completed in the next week to week and a half. So we want to make sure that we provide an adequate amount of time for the proposers in step 2 to refine their information and submit their updated information. So we expect that would be somewhere in early November. We are going to be doing the financial review and analysis with PFM, and they'll need 2 to 3 weeks to complete that. That brings you right up to the Thanksgiving holiday, and the next meeting would be the first meeting in December.
Okay. Thank you.
It's going to take some time to do that.
Just checking.
Okay. Any other questions?
Yes, Mayor.
Oh, yes, go ahead.
Thank you, Mayor. Thank you. And I wanted to thank Alan and Jonathan for their work through the Jacobs report. I thought very helpful, next step for us. So thank you both for that. Mayor, as we think about this next step, just a couple thoughts, and this is maybe going, Mayor, to Ben Rogers and Raquel. And Vice Mayor, I thought, brought up a great point about making sure we're all on the commission in alignment around the criteria. So, Mayor, I'd just like to have a little bit of conversation with Ben and all of us about what criteria is going to be considered in this next step analysis with city staff and PFM, if that's okay.
Okay. Do we have that information right now? What are the next step criteria with the second phase of analysis?
Yeah, so we're working through that right now. I think the overarching probably comment and for commission feedback is it a design, build, finance, operate, maintain? So it's a 30-year leasehold where they're providing the operation and maintenance of the facility, or does the commission have a desire just to do a design, build, finance?
What? What? Oh.
So I guess, Mayor, one of the proposers is asking to speak at this time.
No, this is not the time to speak. We just decided, but this would be the time for any member of the commission who wants to talk to the public and talk to Jacobs what criteria we should now be including in the decision-making process. And you've already initiated some of the ideas. Is there anything more that needs to be added to that discussion?
So, Mayor, could I...
Go ahead, Ben.
Sorry, I can't tell if someone else from the commission wants to speak, but I just had some...
Keep going.
Ideas. Okay, great, thanks. Okay, so some of the criteria, and Ben Rogers, I'll just direct this towards you for what I think are some of the criteria, and we can, kind of as a commission discuss this. So one, I think litigation, right? Ben, is that fair? Is one of the criteria we're going to further look at litigation experience?
Yeah, we'll do a review of that. I don't know if it will be before the next round or if it would be part of the interim agreement or that phase, but we definitely understand that there needs to be more analysis done in that area.
Okay. Yep. I think at least a little bit more there. Okay, great. Financials, which is going to be part of PFM's role. Do I have that right, Ben?
That's correct. As I indicated earlier, we'll be asking for some initial cost estimates back based off of our updated square footage and amenities, and then PFM will do a review of that to make sure that it's in line with industry standards. Okay, great. And experience, which I think Jacobs already did some of that, but I don't know if there's a further dive on experience, and I think we want to broaden that aperture a little bit to across the team in terms of experience on,
public buildings, municipal, city hall. So is that part of it too? Is that fair?
So right now it's not in our next phase scope, but I would encourage that we look at having these teams as they build their presentations for December 2nd, include all that information and have a direct engagement with the commission on their project teams, their experience and qualifications.
Okay, great. Then next criteria, FM, facilities management, which again, Ben, I'm not an expert on this, but one of the possibilities for these projects are to have a contract where there's a degree of facilities management over a period of time. Should that be a criteria listed as if a applicant is interested in doing that or not?
So most of the proposals received to date were for design, build, finance, operate, and maintain. I believe that's the path that we'll be moving forward with, but I would defer to the city manager or the city commission for their feedback.
Okay, I'll pause there for Raquel or Mayor to just opine on that.
Anything further?
Oh yeah, a lot more.
Oh, keep going.
Okay, so Raquel, is that the direction we want to go in? Design, build, operator, finance, maintain?
I think it's too soon in the process to definitively say that we want the maintenance aspect to be incorporated. Okay. I think we would need to take a look at what's provided to us and then weigh our options. And a lot of this will need to be negotiated further once we get into a comprehensive agreement phase. I do think there are advantages and there are disadvantages, and I think some of the firms may be better suited to offer that opportunity, and some of the firms I think are a little bit challenged in that area. So
we never really had that discussion, Ben, whether or not we want to own it or rent it, right?
Right.
But I think that it would be, I don't know whether this is feasible, but is it possible for the applicants to come back with both approaches? What it would cost the city every year if it was a lease purchase versus an outright design build purchase. I mean, can we ask that of them? Is that something that is normally asked for?
Yeah, we can structure our refinement package anyway. So if you want to see alternates, we can add it in there. I just want to caution the commission that, again, we're early in the phase and we're moving through this expeditiously. So I don't think that any of these cost estimates are contractually obligation. And as things get redefined and as they move forward, there might be different numbers and figures down the road. But at this point in time, it would standardize all of the responses to the same criteria.
Okay.
Mayor, can I jump in?
Yes,
I apologize, Commissioner Sorensen, if I could. I just want to piggyback on this. So,
yeah, go ahead.
Don't mean to step on your conversation. Just some thoughts. So I think we need to have them present to us a menu of options, because I'm not sure that I want them to finance when I know our ability to finance is substantially better. But there are some options out there using not-for-profit tax exempt that could approximate our borrowing costs. We also have to think about whether we want to do a general obligation bond, which requires a referendum, or if we want to do more of what we've done or what you saw the county do when the general obligation bond for the courthouse got rejected, where I think they did an excise tax bond. So there's different ways in which we can look at that internally. And I also think we should price out, I think we need optionality here. Okay, so I don't know that I want them to operate in professional outside management. So what I would like is a menu of options that we can look at and price individually, and we can select one from column A and two from column B. So I think that puts the city on the best posture to figure out what makes the most sense for them, and they could each decide whether they want to offer that as part of their as part of their menu that they're offering us. And if I may, and I'm sorry, Commissioner Sorensen, I beg your indulgence. The one thing I'd like to see from Jacobs is, before we define all the criteria for them, I would like them to actually give us a memo with the criteria that they would suggest, and then we could all look at that and maybe come back with, say, yes, I agree with this, this, and this. I'd like you to change that. I'd like you to add this. I think rather than us trying to ad hoc our way to the criteria today, I'd love to see what they propose to us, and then we could add, subtract as necessary at our next meeting. Just a thought.
Great, and yeah, I'm not ad hocing. By the way, I've spent a lot of time with this, so this comes from a lot of discussions I've been having.
Not directed at you, sir. Just talking in general.
Okay, yeah. So Ben, my understanding, correct me if I'm wrong, but the Vice Mayor's point is Jacob's going to continue to be engaged on this, or is it transitioning to staff and PFM?
So the owner's rep agreement with Jacobs is in place. We're examining a number of factors: the timeliness, the turnaround time, some of the things that have internal staff knowledge, and being able to expedite some of those processes by doing it in-house. PFM does most of our reviews for unsolicited proposals or P3 projects, so having them look at the financial aspects is in line with other projects, and then we'll continue to engage with Jacobs and their owner's rep role through various task orders.
Okay, so I guess the short answer is Jacobs will be involved in this analysis, this next step analysis.
That's still to be determined.
Still to be determined.
Yep.
Okay, still figuring that out. Got it. Great. So, and to Vice Mayor's point that, I like the optionality as well. So, I think Mayor and Ben is just, look, in 2 months is a very short period of time to expect the firms to come together with very, kind of narrow down cost estimates, and that's just not a lot of time, especially when we're asking them for optionality and possibilities. So I think if we could get, I think a couple things. What are they willing to provide? What modalities of delivery and financing? What experience do they have in that modality? And then rough estimates of the price of that modality or option. Ben, is that a fair ask, do you think?
Yeah, again, I'll defer to the commission on their feedback and direction on how they want us to include certain elements in the next round, but understand the concerns and understand the feedback, Commissioner Sorensen.
Commissioner Sorensen,
Okay.
I want to add, I think we can add some level of optionality in our request to the proposers. Maybe it's at a high level and it's not as granular as we might want to go if we had a time window that was beyond the dates that we've shared earlier. But I think we can incorporate some of what Vice Mayor Herbst is requesting and still come in on time and on schedule with this process.
Great. That sounds great. And Raquel and Mayor and Commissioners, one of the concerns I had is because this is only a 2-month process, let's say from now to December 2nd, as I mentioned, I think for applicants to really fully do a deep analysis of what exactly the cost would be is going to be somewhat truncated. But and I asked Ben Rogers about this, but our, meaning the city's thinking is ask the applicants to provide an analysis of what they think the cost is. PFM will do an analysis of their estimate so that, in other words, if, Sorensen applicant says it's only going to cost $1 a square foot, well, that could be accurate or could not be, but PFM will do a little bit of analysis to ensure that Sorensen's estimate is in line with their understanding and market analysis and so forth. So I just want to pause for that comment for any feedback or reaction.
Is that possible?
Yeah, so again, I understand the concerns Commissioner Sorensen has on the timeline, and as long as the commission understands that we will get the best information we can, given the timeline and the responses that the proposers have to be able to meet the December timeline, we can do that. So the proposal, the updated information would come in, PFM would then review it, and they would do a financial analysis, and they would identify any major shortcomings or things that aren't in line with the market conditions.
Okay, all right.
Okay, great.
Continue, Ben.
Yeah, thank you, Mayor. Appreciate it. Okay, I'm just looking at the criteria that I kind of think is helpful. So I think those are some big pieces of it. Now, what my suggestion would be if we can do this, Raquel, is you've gotten some feedback, some feedback from the commission here, and there might be more after I, be quiet. But that then Raquel, city staff would then send a email or memo to the city commission saying, okay, here's the criteria in this next phase analysis that we are going to be using. What additions, subtractions do you as a commission have? Is that, can we do that as a next step?
Yes, I think that's feasible and appropriate, and we would give a deadline for the commission to provide feedback.
Yeah. Okay, great. And Raquel, just for clarity, and maybe this is to Dwayne too, but an individual commissioner could provide that feedback one-on-one directly to you, Raquel, right? There's no need to do this at a commission meeting. Am I tracking?
I think the feedback could be provided individually, and if it is the will of the commission to have a discussion, I would say that at the next meeting we would try to have that discussion.
I think that makes more sense to have the open discussion.
Yep. Great. So Mayor, maybe that's our deadline as a commission, is to say we're going to get this memo, evaluate, assess, and then come back next commission meeting to finalize our criteria for evaluation. Is that fair?
Is that fair?
I think that's fair.
Okay.
Okay.
Then, Mayor, the next question I'd have is, so we're aiming for December 2nd. And let's just, Mayor, just for clarity, I just want to make sure, can we just list the 4 firms that are going to be on this, on our remaining lists? I just want to hear their names so we're all clear. The 4 that will progress to the next stage that will present at December 2nd meeting, Mayor.
So, Ben, what are the 4 firms that you're recommending move forward?
I'm going to defer to the manager. I think she has it printed out in front of her.
Balfour Beatty, FTL Beacon Collaborative, FTL City Hall Partners, and Fort Lauderdale Civic Partners.
Okay, so those are the 4.
Okay, great, Mayor. Then my next question would be for December 2nd, so that as these applicants begin doing their due diligence and preparing presentations for December 2nd, Mayor, can we set a time limit for the presentation so that they're aware right now of what that time limit is? And Mayor, I don't know if that's 10 minutes or 15 minutes, but I'd like to be kind of finite today if we could.
Well, I mean, normally we give 15 minutes, so I think that's fair. They should be able to get their point across in that 15-minute time. And then often we add another 5 minutes in case they have any rebuttal or anything they forgot to say. So we would obviously need to allow enough time during that meeting, and I assume it's going to be a conference meeting. We need to allow enough time during that meeting and not have a lot of other items on the agenda so we have a full-throated discussion and presentation, because this is an important decision we're going to be making.
Great. Yeah, I agree. So 15-minute presentation, and then there can be a little bit of rebuttal, or there can be obviously as much time for questions.
Right.
Correct. Mayor,
okay.
Yes.
Mayor, I was going to, when we were talking about the time, I was thinking 10 to 10. I was thinking a little longer amount of time, and I'm not going to say how much more, but if I'm going to ask if we could at least do 18 minutes.
18?
Yes, instead of the 15.
Well, as you know, I'm pretty flexible on these things. So.
Yeah. I figure we can work with that. I won't put out my number that I was going to put out there, but allowing a little bit more time because, again, they have worked on this. They've really put effort into it, and I don't think we should box them in. 15, that's kind of like a rush.
Well, I would like them to be able to send us the presentation ahead of time too.
Okay.
So we studied it and we've swallowed most of the details, and so it's not fresh information as they speak from the dais. So it's an easier process. So, but yeah, I mean, obviously, I'm very
work
flexible.
with the 18. 18.
All right.
18.
Commissioner, I
Commissioner
actually think 18 is too little. I mean, this is a major decision.
I was thinking a little more.
First of all, I don't understand why we're micromanaging this to this extent, everything, but that's okay.
What number are you thinking?
I'm thinking you need to give each of these teams at least 30 minutes.
Go for 30 minutes. Yeah.
Yeah, at least. I mean, maybe I would say let them take whatever they need to do the best job they can possibly do, because this is a very important decision. I don't want to put 15, 18, 20. I don't want to box anybody in right now. I just don't.
And Mayor, we can include the presentations from the teams on the agenda if that is the will of the commission.
All right, we'll see how it goes. All right, very good.
But I think it is important that look. We've got to go. this is a very important project and a very important process. So it's really important that we get clear on all the steps as we're going through. So that's why it's important to get on these details. I know it's not, it's everyone's favorite, but we've got to dig into the specifics. So, and Mayor, it's also a fairness question, because these applicants are going to be spending a huge amount of time and effort on their presentations, and it's only fair that we set expectations for them so they understand how much time they have to prepare. And so, I'm fine with 30 minutes, or it shouldn't be any more than 45 minutes. So,
I think we lose our attention when it's that long. So
I agree.
So let's just be look. Let me make that decision at the time. Let's just know that we're going to be fair and reasonable, regardless of what which applicant is making presentations. So if people need a little bit more time, that's fine. If they can do with less, that's fine. Let's just be flexible. We're not here to stifle the process. We want a full-throated discussion and explanation. So, I come from being a lawyer, and you go into court and you're given 15 minutes to make your presentation, and so you tailor your argument so that it happens within 15 minutes, even though you need 2 hours. So I think that the salient features of any presentation can be done within the amount of time allotted. I just don't want to lose the attention. The fourth applicant is going to be after an hour and a half of listening to all this, and we're going to say, we're not going to give them the attention that I think they're entitled to. So let's keep that in mind also. Agreed.
So aiming towards 30 minutes is what I'm hearing. Great. That's what I'm hearing. All right. Awesome. So So the process as we have it, I just want to make sure we're all clear, feeling good that we're going to get criteria in the next 2 weeks. We're going to do analysis. We're going to come back at the next commission meeting, finalize what that criteria is. The analysis will be done December 2nd. They'll come back, 4 firms listed, 30-minute presentations, a little bit of extra time if needed, plenty of time for all the questions and comments. And then at the December 2nd meeting, our plan is to select one of those 4 to enter into an interim agreement. Mayor, do I have that right?
Yes, sir.
Okay. So I just want to go through. So Commissioner Glassman, are we good with that process?
Yes, I am. Although I would like to make just one request of staff, if we can get all of that further due diligence information in advance of the presentations, the financials, the litigation, all those pieces that have been mentioned by all of the commissioners plus Jacobs, if we can get all of that in advance, I would like to have that ahead of time before the presentations.
Yeah.
Okay.
Mayor,
yes.
I'm just trying to think ahead of this process. When we come back with the proposed criteria at the next meeting, and there's hopefully consensus among the commission, if there is something that presents itself at a later point, but before we come back on December 2nd, I think that I would like us to have the opportunity to incorporate that as part of the criteria. Obviously, I would reach out to
if it's
each
going to
of
have a significant impact on our decisions, needless to say, we don't want to foreclose any opportunity to understand everything about an applicant or their proposal. So yeah, of course.
I just want to have that level of flexibility should something come up, and I don't want to be so prescribed that we're unable to present new information.
No problem.
Thank you.
No problem. Okay, does anyone else want to make recommendations?
Wait, hold on, Mayor. I just want to make sure we're all aligned. So, Commissioner Beasley Pittman, is this sounding
wait. Who's running the meeting here?
Apparently it's Mayor Sorensen.
I guess it's Mayor Sorensen.
No, I just want to make sure we're all
in agreement with what you said.
I'm sure if they're not, they'll let us know.
Yeah.
Okay, great. We're all good. All right.
I'll let you know. Hold on. Time out. I think it's a mistake to exclude Cypress West. I believe that this is the most cost-effective and speed-to-delivery option that we have. I like the other, don't get me wrong, I like the 4 other proposals that we have. I think they're great. I think they're very comparative, and I'm happy to consider them. But, we talk about time as of the essence, and the only one that we can move into immediately is Cypress West. As soon as our police staff are able to occupy our new police headquarters, we can begin to move folks over into that building. And I think to ignore the speed of delivery, the ability to move in immediately and get folks at a very high price rental space in the downtown area is a disservice. So.
All right.
I know that my colleagues don't agree with me, but I want to be on the record that I think we're doing the city's taxpayers a disservice by not taking the least expensive and fastest option to get our folks into a top-notch space that we will eventually own.
Okay, thank you. So, are there any other criteria that you would like to recommend, anyone from the commission would like to recommend to Jacobs and or the other consultants as we proceed forward in this evaluation process? Not at this time. Okay.
Not at this time.
Thank you.
Mayor, I'm going to request that you take an action in the evening meeting to confirm the proposals that are moving forward.
We just did. I thought the city manager announced the 4. We don't vote. So what would you want us to do?
I would like you to vote to reduce the number of proposers.
Oh, tonight.
Tonight.
Oh, tonight. Oh, okay.
Yes.
I'm sorry. Yeah. Certainly.
Thank you.
Yeah.
Is that okay, Commissioner Sorensen?
Thank you for checking it.
I want to make sure you're happy. You're not with us physically, so I want to make sure you're happy.
Very happy. I miss you all dearly.
Excellent. Thank you.
May I proceed? Okay, thank you. All right. Next up, Business 2, Charter Revision Board updates. Who's going to talk to us about that?
We have Anthony Fajardo.
Anthony.
And I believe Paul Bengal.
Okay. So today we're going to hear once again about the recommendations that the Charter Revision Board has made to the Commission preliminarily. Thank you, folks. Made to the Commission preliminarily as to their recommendations for charter changes. And I believe we've all read the backup, which shows the charter section changes, as well as the summary that was provided to us. And so at this point, I'd like to hear from staff as to what these changes are about and what are next steps.
Thank you, Mayor. Anthony Fajardo, Director of Development Services. So we've developed a presentation that I'm going to present in conjunction with the City Attorney's Office. Paul Bengal, as you mentioned earlier, and also Gabrielle Bush from the City Attorney's Office have helped co-develop this presentation along with the backup materials. So I'm going to do the lead-in, and then Paul's going to take over for some of the discussions on the details. One thing I would like to note is that the PowerPoint presentation that's up on the screen, there was a slight modification to it to allow you to follow along with Exhibit 1. So when we get to that section, you'll see at the bottom lower right-hand corner of the slide, there will be a reference to Exhibit 1 and the page number if you choose to follow along that way. So on this agenda, obviously we want to do a quick little summary, go over the amended sections. This is where Paul will be more involved. The deleted sections, that will be a quick overview. Paul will probably touch on some of that during his presentation for the amended sections. A quick little summary on the charter sections that are remaining, and then we have 2 discussion points that we'd like to get clear direction from the Commission on. As you know, the Charter Revision Board asked what you would like them to do moving forward. So a future work plan for the Charter Revision Board, and then a discussion on what you would prefer to see on the 2026 ballot. So just a quick summary of where we are. We tackled, the Charter Revision Board tackled Article 3. This consists of 10 sections, 6 of which were deleted. Either they were deleted because they were incorporated to another section, or they were deleted because there was redundancy with existing state statute or other regulatory requirements. Article 7, we tackled 7.16. Just to note that I did put in the strike and underlines for the titles of the sections, so that's why you're seeing those that way. And then obviously the strike and underlines are going to be indicated in the backup material. There were 6 sections in Article 8, with one of those being deleted for the same reasons, and then section in Article 10 that was deleted for the same reasons. So at this point, and you can see in the lower right-hand side of the screen, Exhibit 1, Page 1 is where we're going to start, and I'll turn it over to Paul, and we can get started. Any questions so far? Good.
Good afternoon, Mayor, Vice Mayor, Commissioners. Paul Bangel, City Attorney's Office. And I would like to start with Section 3.03, and that is qualification of members. So the Charter Revision Board's recommendation is to simplify this section, and they asked us also to separate out the qualifications into bullet points or subsections. So some of the things that this proposal does is it reduces the age for qualification for office from 21 to 18 by requiring the candidate to be an elector of the city at the time of qualification. Currently it's 21. A candidate for city commissioner would have to have resided continuously as a permanent resident of the district rather than of the city generally for at least 6 months preceding the date of qualification. And also in this section, a change would be that in a year in which there has been a redistricting, a candidate whose permanent residence ends up being in a different district as a result of the redistricting can run for office for the district of residence resulting from the redistricting.
Okay, stop right here. So what you're saying is that an 18-year-old high school kid can become a member of the city commission?
If the 18-year-old is an elector, is registered to vote, an elector of the...
Totally against that. I mean, look at the decisions we have to make. There's absolutely no... It makes no sense whatsoever to expect a kid, a teenager, to be able to come up here and to be able to have the experience or the knowledge or the maturity to be able to make, multi-billion-dollar decisions that we have to make here. But you're saying that this was the recommendation of the Charter Revision Board?
That's correct.
Okay. I can't support that. Secondly, we have to firm up what it means the candidate shall continuously reside as a permanent resident. We have to be more specific, because I don't know what that means. So, like when Commissioner Herbst ran the first time, he had a homestead at another location, but he resided here in Fort Lauderdale. So we have to have some criteria other than just a generalized statement like that defines what permanent residency means. Because in the statutes and in the legislative history, it's all over the place. And I think that we have an opportunity here to not allow that to be so vague like it currently is.
And that was part of the discussion also. There's also discussion whether to use the word domicile. They settled on permanent residence because there's a body of case law. There are statutes that could be interpreted that use that term.
I've read it all, and it's very vague. Different courts interpret it different ways, but I think we as a city, since we're changing it now, or planning to change it, that we have more specific definition of what permanent resident means.
And Mayor, could I add to that? Because there was one complication with that. So you mentioned my homestead, which is true. I had a homesteaded property in another part of the state, and that didn't conflict with being a resident. But one of the problems that you have is you can't drop your homestead until the end of the year. There's no mechanism, if you talk to the property appraiser's office, for actually withdrawing your homestead in the middle of the year. So it's done at the end of the year. So even if I wanted to drop my homestead prior to qualifying, I couldn't do it.
Well, I inquired at the time, and for tax
as did I.
Yeah, for tax purposes, you are correct. It lasts you the whole year, but you can terminate your homestead status at any time during the year.
That was not the guidance I received from the property appraiser's office. I talked to the property appraiser in 2 counties. In this county and in the county where I had my homestead, and they both affirmed to me that there is no mechanism by which you can drop your homestead during the year.
All right, so for that,
we need to
firm that up,
right, yeah.
Because that clearly creates more of a murkiness in the definition of what permanent resident is. So I would recommend that we be a little bit more specific at what permanent resident means, so that there's no equivocation about the definition. Okay.
Any comments on the redistricting part of it?
I think that makes sense.
Paul, before you go on, not about the but the beginning conversation about the age. How did that conversation come up where the board was looking at going to age 18 versus to 21? How did that conversation start?
I don't remember the specific conversation. I know I did some research, and I went back to I think it's the 26th Amendment of the Constitution back in 1971 that changed the voting age from 21 to 18, and I think it tracked. I think the intent was to track that, and also I also looked at the statute.
But the eligibility to run as a member of Congress didn't go to 18. You still have to be 25, so that's not a basis. That's not a criteria. Okay, I just want to point that out.
We also looked at the Florida statutes on registering to vote. That was another thing.
Yeah.
Okay. And is there any precedent set with other counties, other cities within our state that they've benchmarked to 18? I'm just curious.
I don't know. I'm sorry, I don't know the answer to that. I don't think we looked at other jurisdictions.
Okay. All right. Thank you.
I don't recall that.
Please proceed. Please proceed.
Sorry, Mayor. I had a
Ben,
question.
I didn't hear you. Okay, go ahead.
Yeah, no problem. Thanks. Paul, thanks. So, determining, I think, residency or domicile. So, Mayor, my question there is, my understanding of how you evaluate that is like a totality of evidence, kind of looking at like voter registration, utility bills, so forth. And my question is, who determines that, and how is it determined, and do we need to more clearly articulate that in the charter?
We absolutely need to articulate it more clearly. I agree with you.
Yeah.
And I don't know whether it comes in as a footnote or something that shows the legislative history of the charter change, that, or we just list the criteria, the total, if you meet, more than half of, voting, where you vote, where your driver's license is registered, where you receive mail. I mean, we have to be more defined there, because it's just unclear by just saying a permanent resident.
So for clarification, are you just looking at the determination of residency or the total qualification for a member of the commission?
Right now, we're just looking at the residency issue. You're talking about the age issue?
No, in terms of the who determines that the person is domiciled. That's part of the criteria for determining whether or not a person is qualified to hold office. So I was wondering if that you wanted to look at the broader issue of determining whether or not a person's eligible to hold office, versus just whether or not they are a resident.
Well, the way these amendments have been phrased, I think in a later article, it said that the city commission makes that decision. Isn't that what it says?
That's the next one. We'll get to that in a minute.
Yeah, it's the next one.
The judge of elections.
Sorry, Mayor, just so I'm tracking, you're saying that, I think there are two things we're talking about right now, if I'm understanding. One is just how to define residency, and then two, who's the judge of residency. Is that
correct?
Right. Okay. And so for defining residency, I think what I'm hearing is we all want a little bit more clarity or fidelity on what that determination is, like what factors go into that determination.
Correct.
So, okay. So Paul or Dwayne, is that something you would then provide some suggestions towards, or
maybe take back to the board and have them come up with criteria?
Yeah.
We can do that, of course.
Yeah.
Some of the discussion,
that makes sense.
Some of the discussion at the board, though, was that if you insert into the charter a list of residential qualification, or what shows or what's dispositive of residence, it would never include everything. So
well, it's not going to include everything, but at least it provides certain objective criteria that, looking at the totality of the circumstances, which suggests permanency or non-permanency of residency. So I think, but right now it says nothing. It just says permanent resident, and that's open to interpretation as we've known over the many years. I've seen this happen more than once.
Actually, I don't even think it says permanent. I think it just says resident.
It says permanent resident.
The suggestion says permanent.
Right.
Currently,
The
it
old
says
one
shall
was
be a
resident.
resident.
The old one just says resident.
Right, the old one just says resident.
Right. So I don't know what permanent is.
Shall have resided in the city of Fort Lauderdale.
Am I
is what the
stuck
current
here
one
for
says.
life? You know.
That's it.
The current one says shall have resided in the city of Fort Lauderdale for 6 months immediately preceding, and shall continuously reside in the city of Fort Lauderdale. Is the current language.
Right. So if we can ask the committee to come back with suggestions, but also, what does the commission think about this 18-year-old qualification? Are you good with that?
I'm fine with 18.
18?
I'm fine with that too.
Well, maybe Ben, you were a prodigy, but
No, I was definitely not. and Mayor, just if the commission wants 21, I'm good with 21 too. But I view it as the electorate will elect that person which they think is best suited, and so I'm comfortable with 18. But I'll turn it over to you all.
Right, I agree, and that person is an elector and able to vote, and I don't have an issue over those 3 years. I really don't.
Yeah, I agree. That's what part of my question was. How do we get to maybe not considering the 18-year-old? We do have some very mature 18-year-olds. We have some that are very engaged and want to be a part of our system.
Right.
And I think that's great.
Yeah.
But are they in a position to make decisions on multi-billion-dollar initiatives?
Some
They
are.
are. Okay.
Well, Mayor, that's for the voters.
I'm worried about the ones that aren't mature that know how to run for office and get elected.
Hopefully we don't elect them, but
That's
Yeah,
for the voters
well.
to decide, Mayor.
Mayor, my comment on this is that I enlisted in the Marine Corps at age 18, so government put a rifle in my hands and told me I could go kill people, so I think we could allow them to run for office.
Then we should lower the age to run for Congress then. It should be 18.
Yeah.
Yeah, I agree.
All right, let's move on.
All right, 3.04, Judge of Elections and Qualifications of Members. So there was some debate over this section, and in the end, the recommendation was to leave the City Commission as the judge of municipal elections and referenda and qualifications of its members because that sentence concludes with subject to review by the courts.
That's the amended recommendation?
The recommendation is to delete the next sentence, which allows any registered elector to file an affidavit challenging a candidate for adjudication by the City Commission. So it would, if you look at the exhibit, it will be the first sentence and the second sentence would be deleted. So the City Commission shall be the judge of all municipal elections and referendums and of the qualifications of its members, subject to review by the courts.
Why do we want to delete the registered elector to file an affidavit? What was the conversation? What was the discussion there?
Do you have anything, Anthony?
I mean, if we're so open,
there was a lot of debate and over several meetings, as a matter of fact, over that.
So what the process as it now exists is that if someone believes that someone is not qualified to run or serve on the City Commission, that can be initiated by a member of the City Commission or by a voter who files an affidavit questioning it and thus brings it before the City Commission to make a decision. Is that how the process works?
Right.
Okay. And if the Commission makes a decision that's adverse to the elector's affidavit, then that elector can then ask for it to be reviewed by the courts. Is that correct?
True.
Why would we? I don't see why we'd want to change that. But,
Mayor, can I comment to that since I have some personal experience with it? I think if any of the other potential electors want to object to the qualifications of a fellow elector, they should do it prior to the election, because what this does is it creates a circumstance where sore losers file objections. if you're going to object to somebody's residency or any other qualification for somebody to run for office, you should do that before the election. Once the residents have chosen somebody, we have an obligation to honor that to the greatest extent possible.
Yeah, that makes sense.
Okay. Keep going.
Keep going. The next section is 3.08.
Hold on. Are we determining who evaluates residency? So we're good. It sounds like we're good with the city commission making that evaluation. Is that?
Do you have another recommendation?
I don't. I think that's ultimately who should. I mean, the only other question I had, Mayor, is it ever like the city clerk that pulls together that, like, for example, the residency analysis and provides that analysis to the city commission for then the city commission to opine on? I don't know. That's the only other thought I had.
Good point.
I don't know if that happens in
Good
other
point.
municipalities.
So when does that question get raised? At the time of filing, or at the time, or at a later time?
I feel like by qualifying.
At qualifying time, right?
Right.
And that would be left up to the clerk to decide?
Well, the clerk.
I don't know. I was just saying the clerk maybe compiles that analysis, the totality of, residency, domicile, evidence, and, presents it to the city commission. I'm not sure.
If anything, I'd rather throw that over to the attorney's office since it involves some discussion about the legal aspects of it. I wouldn't want to put our clerk in a position of practicing law without a license. I get accused of that all the time.
Yeah. Do you think, Vice Mayor, should they do? And do you like that idea of the attorney just evaluating all of the qualified candidates' residency, I guess?
So maybe we should ask that when someone signs up to run for office, that that the city attorney provide an opinion letter as to the qualifications and whether or not they meet the qualifications. And so what would happen after that? Let's say the city attorney says that this person is not qualified. What is the remedy for that applicant from that point forward?
I guess they could appeal to the commission, maybe, Mayor?
Well, if I could add, Mayor, the city attorney's opinion would be just that, only an opinion, which...
Well, that would, but what we're creating a charter change here. So we're saying that that's going to be a presumption of disqualification, which can be rebutted by whom?
It also puts the city attorney in an awkward position because it makes the city attorney actually a witness in the process. And
no, they're not a witness. They're just simply identifying the objective aspects of a person's qualifications. If the city attorney sees that the person lives in Indianapolis and they want to run for office here in Fort Lauderdale, I mean, is that being a witness, or that's just identifying criteria?
Well, when I say witness, I mean if there's a court proceeding that follows, and then it makes the attorney a witness to have to explain where that opinion came from and why.
Well, that's okay. He works for us.
Mayor, here's another idea.
It's an ethical issue, though.
Here's another idea.
Yeah, go ahead. Go ahead, Ben.
And maybe this wouldn't be a charter change, but if when you qualify, part of qualifying is submitting, there's a list of documents to prove residency, and let's say there's 7 items on that list, and part of qualifying is submitting 4 of the 7 documents to the city clerk. Not for the city clerk to make a determination, but for those to be on record that the city commission can then refer to if they want to.
So that would be in line with what is currently provided for under the state election code. It has a filing officer that does a ministerial job of reviewing qualifying papers, but the review of that officer does not include the verification of the information, just that the document is complete on its face.
Mm. Yeah, something like that, Mayor, is interesting.
So can't we just make it ministerial and let the clerk handle this?
That that would be in line with what the election code provides
Yeah.
in that case, where there is a form that the clerk reviews the form to ensure that all of the I's are dotted, T's are crossed.
All right, so, but it's more than I's being dotted and T's being crossed. It's criteria.
Right.
So now it's back in the lap of the city clerk then to see whether or not those criteria are established. So if someone says that they're a permanent resident here in Fort Lauderdale and they show, the
So
driver's
that's the part
license.
that we're wrestling with, which is, again, under the state filing officer doesn't verify the accuracy of the information that's provided on those forms, and we don't think that the city clerk should do that either, nor should the city attorney. The city commission serves as the arbiter of
I
that.
understand that,
Right.
but we're trying to set up a process here, okay? And we're trying to do it in such a way that there's due process that respects not just the applicant running for office, but also respects the authenticity of their being a qualified candidate. So, getting back to what we were saying before, just saying permanent resident is not enough. So we have to come up with other criteria which let the board maybe make a recommendation to the commission as to what that process should be. Maybe they're hearing us now.
Mm-hmm.
Let them come back to us with a process that they feel comfortable with in recommending to the commission. How's that? All right. Keep going.
All right, so 3.04 we'll take back to the board. .08. So in this section, the word absence was added to the title, not that significant, and good cause shown was added for excusal by the city commission. Also, I don't think it's on the slide, but forfeiture of office in the event of conviction of a felony was deleted because of the governor's powers and powers of suspension and removal under Florida law, and also the uncertainty of the mechanics of how forfeiture would work if it's left in the charter. So, on the first issue, so absence of a commissioner from 4 consecutive regular meetings of the city commission shall operate to vacate the seat of such member unless, and this is what was added, good cause is shown and such absence is excused by the city commission by formal action. So that's what was added, the good cause shown.
Paul, I have a question. Don't most of our boards and committees have 3 meetings, consecutive meetings, and you're out? Why, for the commission, would it be 4 and not consistent with the committees and the boards that we impose that rule on?
I don't know the answer to that.
Well, that's the recommendation.
Okay, well, I think we should be consistent with the boards and committees.
Actually, that's not the recommendation. That's the existing charter. The
Yeah,
only thing
the
they're
existing
recommending
charter is 4.
the only thing they're recommending is if good cause is shown.
Well, I think we should either be consistent with the boards and committees and let them have 4, or we should be like they and we should have 3. I just think it should be consistent. That's all. I don't know why the commissions would be any different than our boards and committees.
Could the difference be because you meet more often? That could be.
I'm good with 3. That seems consistent. And
I think 3 is more than liberal.
And the commission can, and if I'm understanding right, the commission can say if you've missed more than 3 and there's good cause, this commission can allow that.
Exactly.
Right.
Right. So so that's a fine.
So the change would be changing 4 to 3. Okay. And do you agree about the language regarding suspension or removal because the governor has that power?
The problem with that is that can be political, and we're leaving to the discretion of the governor as to whether or not to remove somebody, as opposed to our allowing us to make our own decisions for ourselves and not relying on the governor to make decisions for us. Because I've seen where this particular governor removes people from office when he feels that it becomes politically advantageous to remove somebody from office. We've seen that with a couple of state's attorneys, for example. But at the same time, some people have said that a certain sheriff should be removed because of past indiscretions, and that didn't happen. So I think our city, should make its own decisions, creating its own criteria, and we should be the final arbiters of whether or not that person should continue. So I think that language should be left in.
If I may, Mayor, I suggest that you still wouldn't be the final arbiter necessarily if the governor took action, but at least it would be in your charter.
Well, it doesn't have to. We don't have to rely on the governor. The governor still has that option, of course. Yeah.
Is that the consensus?
Yes.
.09, the organizational meeting.
Paul, sorry, can you just remind me, and I'm just not seeing it in the CAM, but what's our deadline again? Just walk me through that again, when we need to have these commission-approved suggestions to go on the charter, to go on the ballot for charter.
I'll defer to the clerk, but I believe this needs to get to the supervisor of elections by June. Is that correct? Do we have a date in June?
June of next year, right?
Of next year.
June of 2026? Is that what you're saying?
Yep.
Okay, great. Thanks, Mayor. Thanks, Paul.
Yeah, and David's looking up the exact date. All right, so on 3.09, this recommendation changes the December swearing in of elected commissioners. It combines it with the swearing in of commissioners elected at a special election and provides for the swearing in to be at the first regular meeting after certification of election results by the Broward County Canvassing Board.
What happens if there's some irregularity in the voting process that is out of our control?
There's a special act that governs, there's a special act of the legislature that governs municipal elections in Broward County, and it provides that the certification is within, this is according to the law, the certification is within 5 days after the election, and, quote, duly elected municipal officers shall take office within 14 days after the general election with the specific date to be decided by local ordinance.
Okay.
So I don't know if that accounts for what for the possibility that you're mentioning. But that's what the...
So if let's say there's a very close election and we need a recount, this certification and the delay of the swearing in only relates to that officer, right? Not the whole commission.
I would think so.
Well, it's not clear here.
Let me see if I have the...
It's only with regard to that specific candidate.
I would think so. That would make sense.
Well, I know you would think so and I would think so, but I just want to make sure we're all clear on that. All right.
Does that change okay? 3.10. So 3.10, actually, there's no slide, I don't think. 3.10 would become superfluous because the swearing in of a member elected in a special election would be covered by 3.09. They were consolidated. So next is 3.12.
Yeah, I think the 6-hour notice is a little aggressive.
So if you read this section closely, the 6-hour notice is actually, actually refers to internal notice. So,
What does that mean?
In other words, notice to each member, the city manager, city auditor, city clerk, and city attorney. So it's not really what I would suggest is that this language might actually predate the Sunshine Law. So the 6-hour notice is for you all to become aware of a meeting within 6 hours.
Well, we need to clarify it so if a special meeting is called and is scheduled to be heard, it's not going to be done within 6 hours.
Right. So what your charter revision board is suggesting is that it replaces the 6-hour internal notice requirement for special meetings with a 72-hour public notice requirement, except that in the event of an emergency, the notice requirement would be upon such notice as is practicable under the circumstances.
Now, before you go any further, Paul, let's just be clear here. The 6-hour notice requirement is not so much that the meeting can be held in 6 hours. It's just the notice has to go out. See, that has to be clarified.
Originally written, I think it probably means that the meeting could be held
in 6 hours, right? So that needs to be clarified because, again, even 72-hour notice requirement. That, say, for example, I feel is important to hold a special meeting. I have to get that notice out within 72 hours, but it doesn't mean the meeting is going to be held in 72 hours.
The way it's being proposed is that the meeting would be held after the 72, with at least 72 hours notice.
With at least 72 hours notice.
To the public. So, the 72
So it
hours...
should say 72 hours prior notice.
Right.
It doesn't say that. Just to clarify it. 72-hour prior notice.
And I'll tell you that the 72-hour requirement comes from the Government and the Sunshine Manual and case law. There was some case law that we looked up. And as soon as practicable, the language as soon as practicable for emergency meetings is in accordance with the Broward County Charter, which also applies to municipalities in Broward County.
Okay.
So also emergency, your Charter Revision Board is recommending a definition of emergency, and that is any occasion or instance in which there is the potential for imminent harm to the public's health, safety, or property, or where the city has the ability to lessen or avert the threat of catastrophe. This was borrowed in part from the emergency management section of the code. Consensus? Next is 3.15. 3.15 is quite involved, and
before you even go there, answer me this question: does this change the current charter to allow 10 people to call a special election?
It changes the current charter to create the committee of 10 people, but there's still a petition process requiring at least 1% of the registered electors at the last election. So it's a little inapposite to the current section.
Right, but the way I read it was that 10 people can call a special election.
Not quite, because it still goes to a petition process.
Well, it doesn't say. It says the proposed amendment will reduce the number of electors needed to start the initiative referendum process from 1,000 to 10.
To start the process. Just to start the process.
Right.
So let me.
Ron, this is a referendum, not an election, right?
Well, it still goes out to the electors like a regular election, yeah.
So I put together a condensed version. So I have a whole prepared presentation on the differences and what the current one says and what the recommendation is.
And that's in the backup. I read all that. But I'm telling you, the way it says now is that the process, the initiative or referendum process, can be started with 10 people.
Yes, but that's to create the initial committee, but it still requires a petition signed by 1% of the electors in the new recommendation.
Where does it say that? I mean, I hope you're right, because I'm looking on page 13.
Well, just look at the summary. Just look in front of us. Look on the screen.
The subsection E1 has the 1% requirement. What you're referring to, Mayor, is that in B, 10 electorates can initiate the process for the referendum proceedings, and they can submit their proposed ordinance to the city attorney, and just based on those 10 people, whereas now it requires the 1% to initiate the review by the city attorney. They're initiating the review with just 10 individuals, and then it's put out to, then after the city attorney reviews it, then it goes out for the petition signing process to move forward to the ballot.
If the city attorney shall have 30 days from the receipt of the redrafted proposed ordinance or proposed petition, or both, within which to find the redrafted proposed ordinance or proposed petition, or both legally sufficient or legally insufficient. So if you say it's legally insufficient, can they still go out and demand a citywide referendum?
In that case, the committee would have 30 days from receipt of the city attorney's notice of legal insufficiency within which to redraft and resubmit the proposed ordinance.
Right. So if the city attorney keeps saying it's legally insufficient, does that block them from putting it on the ballot?
It would until they submit it again in a legally sufficient form.
So at some point, the city attorney will finally say, okay, this is legally sufficient, and then they have to go out and get 1% signatures? Is that the process?
They would get 1% of the electors, yes, signature. So I have a little condensed version of the differences.
I'm reading it right from the statute. I don't want to read your analysis. I'm reading it right from the statute.
But Mayor, look at the summary in front of us on the screen. It's very misleading.
The summary is not the law. The summary is someone's interpretation of the law. Let's read page 14. It says it right here. I just want to make sure that the summary doesn't, and the summaries, what does the summary say?
It's misleading, is what I'm saying.
Oh, it is misleading.
Yes,
that's what I'm saying.
That's what I'm saying.
But, so the law, the statute itself is unclear. Yeah, the summary is not helpful.
No, it's not.
So what you're saying is, if 10 people form a committee, and they submit a proposed ordinance, and the city attorney says, yep, this is legally sufficient, then they go out, it goes to the commission as to whether or not the commission wants to put it on the agenda.
No, then they have to go and obtain the signatures.
Then they get the signatures.
Then they have to get the signatures. And then it comes to the city commission?
Then there's another step between that. Before that, the petitions are submitted to the supervisor of elections for verification.
Okay.
Then the city commission considers the petition. If the city commission fails to adopt within 45 days or fails to repeal within 30, then it's submitted to the electors. And then it's submitted at the next regular municipal election unless the committee prepays for an earlier election or a mail ballot election.
So if the city commission says, no, we don't want to put this on the ballot, and 1,000 people have signed a petition, and those 1,000 are verified signatures.
Not 1,000, 1%.
Or 1%. It's about 1,000, but 1%. 1%. So that 1% can force the city to put it on the next ballot, correct? I'm just trying to understand the process.
That's the proposal.
It still goes on the ballot even if the commission, according to the summary, repeals it within 30 days?
Doesn't approve it.
Doesn't approve it.
Right. It can still go on the ballot.
Oh, it can?
Yeah.
That's still a little awkward compared to what the summary is saying. It's a little misleading.
I mean, I'm okay with that process as long as I know what the process is. So you have 10 people who form a committee. They, I don't know what the qualifications of the committee are, but let's just assume there are 10 voters, and they form a committee. They put together a legally sufficient ordinance or referendum asking for there to be some ordinance change or modification. And it goes to the city, and the city attorney says, yes, this is legally sufficient. And then it goes to the commission. After having gotten 1% signatures, commission says, no, we don't want this to be voted on. And so the people that the committee of 10 can then go to the supervisor of elections and require that be put on the next election ballot. That's the process, right?
Can I direct your attention to page 11 of 42 of the section?
Page 11, yes.
So if you look at the bottom of the page, that's the paragraph that I think we're talking about. Action on petitions in G. So, if you don't mind me reading.
Action by City Commission. Upon receipt of a certificate determining the petition is sufficient, the City Commission shall promptly consider the proposed initiative ordinance and reconsider the referred ordinance. If the City Commission fails to adopt the proposed initiative within 45 days or fails to repeal the referred ordinance within 30 days, it shall submit the proposed or referred ordinance to the electors of the city. If the City Commission fails to act on a proposed initiative ordinance or a referred ordinance within the requisite time period, the City Commission shall be deemed to have failed to adopt the proposed initiative ordinance or failed to repeal the referred ordinance on the last day that the City Commission was authorized to act on such matter. So when you say submit to the electors, that means that those folks take it to the supervisor of elections office and say, we want this on the ballot.
Well, I would suggest that since it's in the charter, I think the city staff would probably facilitate that.
The city staff would do that.
Would need to facilitate that with the supervisor.
Now, if there's an additional cost for adding that on the ballot, who pays
that's addressed also.
Does that committee pay for it?
The committee would not pay if it's at the next regular municipal election, but if the committee wants an earlier election or a mail ballot election, then the committee would need to prepay the cost.
Okay, but if it's on the regular election cycle, then the city's responsible for any costs associated with that.
Right, if there are. I don't know if there would be extra costs.
There are.
Correct. The supervisor recently changed it where when you have strictly just municipal officer elections, there's no charge for that. But for referendum ballot questions, there is a charge. And obviously, if they wanted to do a mail-in ballot prior to, there's a charge, and it's a lot more.
But according to this proposal, that would be covered by the committee. That would be prepaid by the committee.
No.
But what about in November?
A mail ballot.
The mail-in ballot. Yeah. Okay.
Yeah, but if it's intending to go on a regular election cycle in November, then the city pays for that, which could be several $100,000. By the way.
So for November 2026, like for
right.
referendum questions, it was
right.
around 300,000.
Yeah. We good with that?
Mm-hmm.
Mayor Sorensen, you have any thoughts on that?
No, I'm done leading the meeting for today. Thank you.
Do you want me to contrast that with what you presently have, or is that not necessary?
Yeah, sure. Tell us.
So, and again, this is the condensed version. I have a whole long thing prepared if you want to hear the lengthy one. But so currently, a committee of 1,000 electors to start the process.
Right.
The committee can request city attorney assistance in drafting.
Right.
Then there's 60 days notice to the city manager to present it to the city commission. If the city commission rejects or fails to take action, then the committee demands an election. If refused, the committee circulates a petition and obtains 15% of the electors to compel enactment. If 15% sign the petition, then it is mandatory for the city commission to enact the ordinance or call an election to submit the proposed ordinance to the vote of the electorate.
So 15% is necessary
15%.
Sorry, where was that, Paul? I missed that.
I don't remember that. I don't remember 15%. I always thought it was, the original says 1,000 electors.
Right, that was. I don't remember the 15% either.
Did I get that wrong? Let me see. I'm not seeing.
Do you remember 15%? I don't remember 15%.
Paul, I think it's in 3.16.
Oh,
it says,
okay, I'm looking at 316.
After a demand of election has been refused, as herein before set out, the committee shall have the right to circulate petitions to obtain signatures of registered voters of the city equal to the number of 15% of qualified electors.
Which section are you
It's
reading?
in 3.16.
Thank you, Anthony. Yeah,
3.16 what?
of our current charter.
Of the current charter.
Yeah, but it's got multiple sections. Which paragraph?
It's right at the beginning. It's at the very first. It's at the very first.
After demand for an election has been refused. Oh, I see.
By the way,
the committee hold on a second. Shall have the right to circulate petitions to obtain the signatures of registered electors of the city equal in number to 15% of the qualified electors in order to compel the enactment of such ordinance.
So what I should have said at the beginning is that the proposed 3.15 replaces 3.15 through 3.20.
Okay, but what this says is that if 15% of the electors vote for it, then it's automatically an ordinance. That's different than what we're talking about. We're talking about how to initiate the request for a ballot referendum. This just says if 15% of the qualified electors
Well, it compels enactment in the following
compel
way.
the enactment.
So
if 15% of the 15% of the electors, that needs to go. Because now we don't, this was written when we had March elections, and 15% was a lot of people. So that needs to be changed.
Well, as I said, the new 3.15 would replace all of this.
Okay.
It replaces 3.15 through 3.20.
Okay.
Thank you, Anthony.
Yeah, I see where it's all crossed out. Okay.
And Paul, going back to 315, the 1% gets. Remind me what the 1% benchmark is.
So the committee submits the ordinance and the petition to the city attorney, and petitions are signed by at least 1% of the electors in order to be submitted to the supervisor of elections for verification. Then the city commission considers the petition.
Yep, considers the petition, And if the commission basically fails to act according to the petition, then it can go on the ballot?
Correct.
Okay. And is that was one of my questions, Mayor. Is the 1%, is that like the normal standard in other municipalities, or?
The mayor has left the building. Vice Mayor is in charge.
Vice Mayor. That's my question to Vice Mayor, to Paul, or just is that 1% the right standard?
There was discussion about that. Actually, that 1%, I believe, came from the prior Charter Revision Board, and I believe it was compared to other jurisdictions, but I'm not sure exactly where the 1% came from. That was the suggestion at the time, and the current board agreed. But I think that goes back to the previous board.
Okay.
Paul, according to my notes, it said it was consistent with state law that was 1%. Does that sound?
Yes, but for referenda, for other things. It's not that state law governs this, but I believe there is something in state law for referenda with that same 1%. I don't remember where that comes from exactly, but that's right. But it's not that it governs these municipal referenda.
Okay, great. I'm good with that then, Paul. Thanks. You can go on to whatever's next. Thanks, or at least for me.
Do we have a consensus on what to do, how to proceed?
I think so.
All right, so the next one would be 7.16. And this really is just a cleanup thing. It's a cleanup provision to delete some residual and ineffectual language that was related to primary elections that wasn't removed during the last charter amendment in 2019. It's ineffectual. It doesn't really do anything, but it's to clean it up.
I don't think there's any issue with that.
Next one. 8.0, now we get into public property. So 8.01, sale of personal property. In this proposal provides for personal property belonging to the city to be sold in accordance with an ordinance that would be enacted for that purpose, thereby eliminating some of the requirements that are currently in the charter, like forbidding publication of notice for the sale of personal property, the value of which exceeds $5,000. Obviously, ordinances are more easily amended than the charter. And this, again, is only as to personal property. So personal property as opposed to real property, these are things. Equipment, maybe vehicles, things that are not real property. Any discussion or direction?
I think $5,000 is awfully low.
Yeah, so this proposal would eliminate.
Yeah.
Would eliminate that.
Okay.
Next. Eight point 8.02 is the sale or lease, well, as amended, the title would be sale or lease of city property to public bodies. And the proposed revision to section 8.02 requires adoption of a resolution by the affirmative vote of at least 4 commissioners for the sale or lease of property to public bodies or the allowance of a public body to make improvements on property owned by the city, and requires a public purpose which is defined based on case law as an activity that is essential to the health, morals, safety, or general welfare of the city, as determined by the City Commission, notwithstanding an incidental benefit to a private party. So in other words, a lease of a government building to another government for government use, it would have to be for a public purpose. It would be for some government use or some other public purpose. And for example, it could allow maybe a cafeteria or a sub shop as an incidental private benefit if the lessee wants to do something like that. But it wouldn't allow a sublease of the entire property for a private use. Continue? 804? Or any discussion?
Let's take an example. The most recent example is like the Bahia Mar. It was public property, and
Go ahead, I'm sorry.
Is that considered a public use?
Well, this is...
we leased it.
Bahia Mar has a separate section in the charter. That's a totally different thing. This wouldn't apply to that.
And this section is to leasing to another public body, correct?
Right.
Oh, we're still talking about that. Okay,
to a public body.
I thought we were talking to a private entity.
No, not yet.
Okay.
That's coming.
Well, there's nothing controversial about this one.
No, the only thing is that it would allow the incidental private use, some kind of incidental private benefit. But the paramount purpose, the main purpose, would be for government or public, not necessarily government, but would be for public use, public purpose. Ready for 8.04?
Where does it is essential to the health morals? What do you mean morals? Does the city have, like, defined morals?
Well,
okay.
They put in there as determined by the city commission.
Okay. Yeah, we can get rid of the word morals.
Get rid of morals?
I'm going to add a few morals.
Ready for 8.04?
Keep going.
That's a yes? Okay. On 8.04, sale of real property to private parties. The name is changed, the title is changed a little. The recommendation is that the city's sale of real property to private parties be as provided by ordinance and consistent with applicable law, and subject to adoption of a resolution by the affirmative vote of at least 4 commissioners containing a finding that the sale would be in the city's best interest. So there's a caveat that Section 8.04 is subject to 8.21, which I'll get to later, but 8.21, which, if adopted, would require a special election referendum to sell or transfer any land that is zoned parks, recreation, and open space. So, with that caveat, it would take a resolution by the affirmative vote of at least 4 commissioners to sell real property to private parties.
Well, it doesn't say sell. It says sale, exchange, conveyance of approved or unimproved real property.
Yes. Yeah. All right, sell, exchange, deed, or convey, yes.
So now let me ask you this. What happens if we're talking about, a half an acre of land that we have designated as public? Can we rezone it? Can we rezone it and get around this qualification? I hate to have a public referendum on changing on selling a piece of property that's maybe a quarter of an acre or a half an acre. I mean, it just seems.
So that's land. The qualification, the caveat is for land that is already zoned.
I
park.
understand
Yeah.
that. And we did a series of rezoning a couple years ago, and we rezoned many pieces of property as public, as
parks.
as park. And some of those pieces were really small.
Mm-hmm.
So I'd hate to have to spend $300,000 to have a referendum to make a decision on whether or not to sell a piece of property like that. And can we just rezone it?
Mayor, Anthony Fajardo. So in the current language, it says, additionally, any land zoned park on November 10th, 2004 shall require a unanimous vote of the entire city commission to remove such designation. So you have a high threshold for the rezoning as well.
But what I was referring to, though, is 8.21 as recommended for amendment.
Right.
We'll get to that in a minute. That's how it.
That's
right,
okay.
That's how it is,
I mean,
correct.
as long as there's another way to do it. I mean, I think it's always been part of our charter to require unanimous decision to rezone parklands.
That came into the charter around 2004.
Yeah.
And that's in the existing 8.21.
Right.
Yeah.
And so what I was referring to as the caveat is the recommended change of 8.21, which I haven't gotten to yet.
Okay.
Yeah.
Okay.
So all right, depending on what you do on 8.21, that affects this.
Keep going.
8.09. Leases, licenses, concessions, and use agreements. This title also is recommended for amendment for more than 1 year and not more than 50 years. So the Charter Revision Board recommends amending 8.09 to clarify that all use agreements, including leases, license agreements, concession agreements, facility use agreements, and other types of use agreements with private parties for the use of real property owned by the city are subject to a 50-year maximum, including any renewals or extensions. The City Commission's approval of an instrument would be subject to the following. Approval of any instrument having a duration exceeding 1 year would require a resolution adopted by the affirmative vote of at least 4 commissioners containing a finding that such use of the property would be in the city's best interest and the City Commission's consideration of a fair market value analysis of the property prepared by a qualified independent consultant hired by the city at the private party's expense. And in addition to the requirement of a fair market value, the approval of an instrument having a duration exceeding 10 years, including any optional renewals or extensions, would require the City Commission's consideration of an accompanying business viability report prepared by a qualified independent consultant hired by the city at the private party's expense. And also, each instrument must contain a provision prohibiting assignment except upon the affirmative vote of at least 4 commissioners.
Okay, so back to my example before, which concerned the Bahia Mar. We would, under this new provision, we would not be able to strike the same deal that we've done with Bahia Mar, correct?
I don't think this would apply to that because it has its own provision. I'm not sure. I'm not sure about that. I'm aware of a city attorney opinion back in the early 2000s. I don't know if that was applicable to Bahia Mar, but that is where the 50 plus 50 was interpreted. The charter was interpreted to allow that.
Yeah, but this change doesn't allow it.
This change wouldn't allow that.
That's what I was saying.
Right.
Right. So I'm not in favor of that. I don't know about the rest of you, but because the way the state statutes work, you can't sell condominiums for 50 years. So, I mean, it would have tied our hands, and I believe this commission voted. What was it, 4-1? 4.
So remember, though, this is leases, licenses, concessions, and use agreements. So This is not sale. This one.
Well, it would preclude us from having entered into an agreement with Inter-Miami. Inter-Miami is a license agreement. for 50 plus 5, I think.
The extra 5, I believe, is currently in the charter currently for construction. There's an extra 5 that can be added to
for construction purposes.
I think
right.
I think that's
what you have now.
I think that's what we have now.
Right. I'm not in favor of this. I just think it ties our hands, and especially if at least four members of this commission, approve something, or even unanimously, I just think that we shouldn't tie the hands of the commission under these circumstances. Does anyone else have an opinion about this?
I agree, but I also want just some clarification. So, Paul, prior to that, it was just a majority, right? It wasn't 4 out of 5. It was just 3 out of 5, right? I remember reading that somewhere, and I can't find where I took that note, where we're actually increasing the threshold now from 3 to 4 to a supermajority.
So this is one that may have been silent, and if it was silent, then yes, it would be a majority.
So I think that I agree. If we're raising the bar to make sure that it's 4 out of 5, then I think that we have to keep the 50-year provision the same, because you are giving yourselves that extra added necessity of having 4 out of 5, and I think that's enough.
Anyone else have an opinion on this? Ben?
So the 50-year, is the 50-year a new additional limitation?
Yeah, we currently have 50, but it allows for extensions, renewals or extensions. This recommendation statute works. You cannot offer a property as a condominium if it's just 50 years on leased property. So it precludes what we allow to happen in like, for example, Bahia Mar. It would preclude. Again, I don't know. For some reason, I don't know if anyone here, Anthony, do you remember what we did with Inter-Miami? It was 50 years plus. I know it's hard. I don't mean to put you on the spot. I don't remember what the exact.
I think Inter-Miami is just 50 years. I don't think it extends beyond that. We didn't do the only 2 that I'm aware of that I recall is One Stop, where we did a 99-year license with them, and Bahia Mar, where we did basically we approved 2 leases all at once.
50 and 50.
Right. Yeah. One thing I want to kind of introduce into this conversation is we might just want to set a threshold for this too. If there's an appraised value of the property in excess of, and I'm going to pick an arbitrary number, $5 million, then we look at that. If we're talking a small parcel or something like that, we may not want to go ahead and do that. But I think, when we're talking public property for 100 years, I think, maybe having a unanimous vote, this is something that's going to impact generations. So I would be in favor of it.
So which issue are you speaking to now?
So the idea that we create maybe a threshold for the public property. Can we go back to the? We lost the display up there.
You're talking about the city being able to sell public park property.
Yeah.
You think that a $5 million?
Yeah, can we put the text back? Thank you. So, right, for not more than 50 years. So, amend the language that if we're going to go with a supermajority, I think we should have some reasonable level of appraised value for the property. So, if we're doing something small, we don't necessarily need to do that. But if we're talking a significant parcel, and there's only a handful, I think, in the city that are really going to meet that threshold. So I think that would be important. But other than that, I would also support the idea. Because one of the problems we had with One Stop, and this is not criticizing One Stop, the deal, or anything else, but just there was conversations, I know, between myself and the attorney's office about the difference between a license and a lease and some other things. And I know there's some case law on this as well. So I think this was, to some extent, also an attempt to make sure that they were consistent. Does that make sense, Dwayne? Is that consistent with your understanding when you and I had these
Yes,
conversations?
there was definitely questions with regards to what constitutes a license in case law, and courts have found agreements that have been said to be licenses to be leases based on their terms. So clarification on that point is one of the things that we do want to have in any change that you have to this section.
So I think, Mayor, that was part of the rationale when the Charter Revision Board was looking at this, was just to have consistency between what's a lease, what's a license, and so forth.
Well, that I understand, but this 50-year thing, I can't be in favor of that, because it should be at the discretion of the commission, and let it be a supermajority to make that decision. But I still think the commission should have that ability to make that decision at the time.
Yeah, I mean, I like having 50 years. I don't know why I like having that. The commission can be revisited, 50 years at a time.
But Ben, the problem is that at the starting of the 50 years, it limits you to what you can build on there. You can only build rental units with a 50-year lease. You cannot build condominium units. That's the difference, because the state statute does not permit it.
Which in this case, we would have been stuck with about 650 rental units versus 300 or so for sale units. Because
how many years does the state statute require?
99 years.
Right.
So city attorney, requires 99 years?
I'm sorry?
Ben, what's your question?
He's asking for clarification if we have to have 99 years state statute to sell.
With regards to
building condominiums, you cannot build on a leased property with less than 99 years lease on the property to be able to sell it as a condominium.
I'll defer to the real estate attorney on that.
Oh, all right. Well, I'm not going to be the expert here, but I do know
I'll look it up and
I need more clarity on that.
I'll look it up and I'll.
All right, we can revisit it. We're not making decisions today. So.
And Mayor, if I may, I'd just like a little clarification. Wherever we keep seeing 4 commissioners all over, do we need to, obviously there are only 4 commissioners and a mayor. Do we have to be more specific, or is this enough?
There's language in the charter that addresses that and says that the 4 commissioners plus the mayor are sometimes referred to as commissioners. That's in the.
Okay, I just want to make sure, because we just keep saying.
That's what's intended. Sure.
Okay, I just want to make sure, just for clarity's sake, that if you think that's strong
just
enough.
Say 4 members of the commission.
Right, I think that's just better.
Okay.
I think this should be unanimous. I mean, I'm fine if we go with 100 years. I'm okay with it. I think this should be unanimous. This is public land, right? That's what we're talking about.
I'm okay with that too.
Yeah.
I'm okay with unanimous.
Okay.
Yep.
Yeah, I think if it's unanimous, then 100 years, I'm good. Or beyond 50.
That means 1 commissioner can hold up the whole thing.
Yeah. I just think it's that important, so we got to have alignment.
By the way, I found where in the current charter it says for a period of not more than 50 years plus such length of time, not to exceed 5 years, determined by the City Commission to be reasonably necessary to complete construction of the improvements proposed.
Right.
That's where that comes
from.
Right.
That's where that comes in. Right. Okay.
All right, good.
Keep going.
So, Paul, are you tracking that?
I'm doing my best.
Okay.
821.
Paul, are we talking, well, go ahead. I have one other question, but it's a separate topic, so go ahead.
Fortunately, it's being recorded, I guess. Okay, 8.21, disposing of, the title's changed from public to park property. And the current language is pursuant to, as I mentioned before, is pursuant to a charter amendment in 2004 and requires any sale, transfer, or lease for more than a year of land zoned park to be by unanimous vote of the entire City Commission. As redrafted, if adopted, it would require a special election referendum to sell or transfer any land zoned, and it actually uses the ULDR terminology, zoned parks, recreation, and open space, and would require a unanimous vote of the entire City Commission to enter into any lease, license agreement, concession agreement, facility use agreement, or other type of use agreement for more than 1 year with respect to any land, zone, parks, recreation, and open space. So, in other words, that section was bifurcated between sale and lease.
Well, this is different. This is park property versus public land.
Right.
Yes,
Right.
this is park property, but currently, this section says that notwithstanding anything to the contrary in the charter, the city shall not sell, transfer, or lease. So it's addressing those actions altogether. Shall not sell, transfer, or lease for more than 1 year any land, zone, park in accordance with the city's ULDR without a unanimous vote of the entire city commission.
So
that
we
was
can
separated out.
avoid the referendum if the city commission votes 5-0 to remove the park designation.
I guess if it's not zone park.
I can't.
It's not zone park.
When you say you guess, we have to have clarity here. So, if there's a piece of property, like half an acre, that we've already designated as park, and we want to go sell it, or lease it, or license it, can the city commission just remove the designation without having to go to referendum?
The way this is proposed, yes. But let me add something to what was done in 2004. So in 2004, there was a date that was inserted into the charter so that it says currently any land zoned park on November 10th, 2004 shall require a unanimous vote of the entire city commission to remove such designation. And in this iteration, the date was removed. So conceivably, you could put the same requirement that they did in 2004 to this proposal, so that any land zoned park on such and such date, whenever this were to go into effect, then that would still require a unanimous vote of the entire city commission to remove the designation.
And if we don't get unanimous vote, then it would have to go to referendum. But as the vice mayor suggested, maybe we should put a dollar figure there.
I like this unanimous. I think the hard thing with the dollar figure is just what is it, and times change and inflation and so forth.
Well, like if the property is worth under $5 million, we shouldn't have to go through all of this. It shouldn't require unanimous vote.
Yeah, I still like having it unanimous, me personally.
You still want to keep it unanimous?
Yeah, just because it's park land and it's.
All right. But if the commission does decide to remove the designation, and it does it unanimously, it can avoid the referendum.
Right.
Your mic is off.
Microphone.
Your mic is off. Keep pushing. Keep pushing.
It died.
You wore out the microphone, Paul.
Yes. Would you want to insert a date so that any land zone park as of a specific date would still require the unanimous vote?
Wait, say that again?
Yeah, really.
So, in other words, to remove the zoning designation
For park,
for park
we want
Right.
a unanimous vote.
of land zone park at any time, or
Well,
or when the
current.
when this section goes into effect. Because I think that's what they tried to do last time in 2004.
Well, when the section goes into effect, yeah. Whatever the status quo is at that time. that it?
That's it.
Okay.
Paul,
Other sections,
Mayor,
perhaps.
one other question. It's Paul, in the charter, the vice mayor, is the vice mayor still in the charter, like assume office or appointed in April or?
Yes, that is in April because that dates back to when elections were in March.
Yeah, can we
need to
change
change
that?
that.
Certainly.
We need to change
That's
that.
something that
In December.
I don't believe the current charter board has addressed that section yet, but certainly.
All right,
Easy.
let's change that to December.
December?
Yeah. The second meeting, I mean, I'm still not keen on that the next meeting after the election or after the because that has other ramifications. I think we should keep it December. But aside from that, I think the vice mayor should be chosen the second meeting in December.
The problem with keeping the term beginning in the swearing in December is the special act suggests otherwise.
The what?
Special act.
What do you mean?
The special act governing elections in Broward County that says certification is within 5 days, and then the elected official should take office within 14 days. So if your election is in November, beginning of November.
Mayor, I know we talked a little bit about this, but I think, and maybe you all clarified this, but so I think the commissioner, it seems to me we've got to make a distinction between commissioners' individual elections being certified. Like your election could be certified, beginning in November. Someone else's could not be certified until January. I mean, it's just possible, right?
Right.
So it seems to me, Mayor, it should it seems like we should, that the city commissioner or mayor should be validated, affirmed, seated at the meeting, the immediate meeting following that certification, because they might not all be ready by December or by the first meeting after most of the elections certified.
Right. I agree.
Right, so I don't know what it's getting into the weeds, Mayor, on that language, but I think we actually have to do that to make sure, like, it may be the case that 3 of us are seated, but the 2 still take another month for some reason.
Well, that may be the case, especially if there's a recount.
Right, exactly. Paul, does that make sense, what I'm trying to say?
I think it does, but allow me to read from the special act. So it says that in any general election in races for municipal offices in Broward County, the candidate or candidates, depending upon the number to be elected, receiving the highest number of votes in the election shall be the winners. Such duly elected municipal officers shall take office within 14 days after the general election, with the specific date to be decided by local ordinance. So that's a special act of the legislature governing municipal elections in Broward County.
So we can decide when they take office?
Within the 14 days following the general election.
I mean, so Mayor, I don't know, Paul and Mayor, if you could say this, but you could say that in the city of Fort Lauderdale, that person is sworn in or takes office following the certification and within 14 days of the election. I don't know.
But what happens if it's not decided?
Exactly. So the state law must allow for it going beyond the 14 days, right, Paul? If it's not certified.
There are probably Department of State rules that address that. I'm not sure offhand, but
Yeah.
that's why the board suggested measuring it from the time of certification, the next meeting after the certification.
Right. So the certification may be in January if there's a runoff, or if there's a tie, meant to say.
Yeah, time.
So it's within the 14 days after the recount.
And that's where Mayor, I think the vice mayor discussion is separate from the election. Like, in other words, we could just say the vice mayor is appointed the first meeting in December, and that really doesn't matter who's on the board on election day or not, who's on election year, who's been certified or not. I mean, the commission can kind of figure that out, but that's a standard is the beginning of December for the vice mayor.
So this raises another question. So we have an election in November,
Right.
and let's say the mayor's race is a close call, and they have to have a recount, and for whatever reason, the recount's going to take several weeks. Does the current mayor sit there until the decision is made as to who finally wins? Is that how it works?
The term goes until the successor is sworn in. Is my recollection. But I'm just I'll speculate a little here. It could be that the April selection of vice mayor dates back to when, and again, I'm speculating.
No, it dates back to when we had the elections in March.
But not only that, not only that the elections were in March, but the city also probably ran its own elections and probably canvassed the results itself at one time. And
Okay,
that's still in the charter, actually.
All right, but I don't think that's a controversial thing. I think we could still do it in December. Okay. All right. Does anyone have any questions? A few people sign up to speak if they're still awake.
Mayor, there's still more of the presentation.
There is.
Yeah, just to kind of go over. I mean, Paul touched on the ones that were deleted already, so I'll just go through those real quick. You already know about those, but some of the
Thank you, Paul.
salient sections that are still remaining are Article 5, Administrative Organization, Article 6, the Civil Service System.
Isn't that like cleanup language?
Yeah, and that's the guidance we're trying to get is there are some other sections that involve the items that were being presented by the city manager's office from HR that we're going to bring back, and then there's the issue of strong mayor that they wanted your input on. So we're trying to figure out what would be the desire of the commission for the work plan moving forward for the Charter Revision Board. If you want to do what the chair had recommended for the city attorney's office to run through and do a cleanup on it and then present that back to you, or if you have any other specific topics that you'd like us to bring to them for consideration.
Anthony, if you could go to the podium, I think that would be helpful. Thanks.
That was my own
I heard you. So you come back, because these haven't been fleshed out, my understanding. I mean, are you prepared to make a presentation on these?
No, we're not.
Yeah.
We're just trying to get guidance if you would like them to look at them or us do a cleanup of the whole thing and then bring that back. I mean, however, whatever your desires are.
I think that makes the most sense, yeah. But also I'm going to visit with the Charter Revision Board myself, and there are a couple things I wanted to talk to them about. And so they may or may not adopt any changes, but I just want to have a conversation with them myself, as anyone on this commission can do the same. But there are some things that I would like us to further consider. So I think the work so far has been amazing, and I appreciate everyone on the Charter Revision Board for participating and putting in the many long hours to get to this point. So hopefully we can get something together for the 2026 ballot.
And speaking of which, is there any guidance on what you'd like to see on that ballot? There's been a lot of discussion on whether or not it should be everything, because then that volume would probably confuse some people if they're trying to read too much, or should we target certain items and issues so that they can go on this ballot and then have a separate ballot later on?
Could I throw out a thought for that? So we've got a March election coming up, right? There's municipal elections in March. Could we do a ballot in March, or was it too late for that now?
It would probably be too late because of the 45 days prior to sending out ballots. It would be tough to make it there, and also all the polling places aren't open. It's only the municipalities in November, countywide is
Gotcha.
open.
Okay. All right. Thanks.
Yeah, they're not open in Fort Lauderdale, right?
Right.
Okay.
Yeah,
I'd say put everything on the November ballot. we're thinking November of 2026, right, for this?
Yeah.
Yeah, I'd say put everything on there. The voters, they can handle it.
Let's figure out what everything means, and because we could have 2 pages on the ballot of charter amendments. So, all right. So we'll get there.
And that will help guide our outreach to the public for educational purposes and moving forward with that.
Okay, great. All right, thank you.
And Mayor, real quick, one thing that I forgot to put on the commission or the holiday calendar we looked at, November 3rd is our first meeting, November 2026. November 3rd is Election Day, and that's also the day we meet on. So we don't have to, I guess, make a decision on potentially if you wanted to move the commission meeting off of November 3rd because that's Election Day.
Well, we're not there yet.
No, I know. But we just talked about the calendar before, so.
Okay. All right. Thank you.
Mm-hmm.
Can we discuss that at the next conference meeting in a couple of weeks?
Yeah.
Okay,
Yeah.
thanks.
It's a year away.
But they set this calendar. We set the calendar last commission meeting with the changes, so he wants to just get them all done at one time.
Okay.
Right.
All right. We have a few people who signed up to speak. Bill Brown, who lists his address as 112 North Birch Road, Indianapolis, Indiana.
I did that for a reason, Mayor, to see if you would pay attention and catch it. I grew up in
Well, I don't want to
Indianapolis,
confuse
sorry.
anybody. I don't pay attention, so.
Good afternoon, Mayor, Vice Mayor, members of the Commission, Bill Brown, President of the Council of Civic Association. I, too, would like to commend staff and the Charter Revision Board for the time that they've really spent the past couple of years getting to where it is today. But I'll be very brief in saying that the council would like to be actively involved as we started out earlier in the process of hosting divisional or district meetings with the 4 districts, invite the commissioner and our district reps and the presidents and their boards or anyone from those 4 commission districts to participate in the public outreach. As you have seen, this is a big elephant. There's a lot of material to absorb. After sitting here 2 hours, you know what I'm saying. So I think we're going to have to take this in small pieces. So what I would ask the commission to give staff the authority, working with Anthony, coming up with a plan on how we can start engaging the community on some of these changes instead of waiting till later next year and then hitting them all at once. And doing some public outreach.
Okay.
So if you would empower staff to do that, we'd be greatly appreciated.
I think that we would appreciate that.
Thank you.
Jim Concannon? He spoke for okay. All right. Ditto. Marilyn Mamano, followed by Barbara Stern.
That's for you. Oh, you're not.
I turned your mic off. No.
Thank you so much. Good afternoon, Commissioners. I'm giving testimony on behalf of Lauderdale tomorrow. But before I read my testimony, I would like to say that having sat through this very, very detailed conversation, which I am probably one of the few people in the room who enjoyed, Commissioners, my name is Marilyn Numano, and I'm here this afternoon on behalf of Lauderdale tomorrow to address proposed changes to Section 8 of the City Charter. We're only talking Section 8. Lauderdale tomorrow has been committed to preserving public lands since we began. We have advocated for using public lands for a public purpose and defining public purpose in the Charter. On May 21, 2024, we advocated for putting the changes proposed by the last Charter Revision Commission on the November 2024 ballot to give the citizens of Fort Lauderdale the ability to vote on changes that would promote and protect public lands and define public purpose. The majority of this commission decided on that day not to put those changes on the ballot, primarily because they felt there had not been enough public comment. It has been 17 months since that day. A new Charter Revision Board has been seated, and there is still no public outreach, which is going to change now based upon your discussion, okay? But I didn't know that at the time. The changes to Section 8 proposed in Exhibit 1 are primarily the same. There is one minor language change, but we could talk about that as we go forward. But they're essentially the same. Nothing has changed. We hope that you will move these items forward today so that they can be put on the ballot next November. We urge you to start the public participation process. Our intent, as always, is to work with you for a better Fort Lauderdale. However, we believe that this is so important to protecting public lands that if you choose not to move forward, which you have chosen to move forward, but if you choose not to move forward, I have to read it because this was adopted. If you choose not to move forward, then we must consider moving forward on our own with the work prepared by the Charter Revision Board in Section 8 for the Charter and bringing it forward to the voters. Again, this was written previously. Now, and we're so happy that we don't have to necessarily do this, but we were prepared to do this. This is a statement of frustration from 10 years, a frustration with the way things have gone down in a number of instances, and we're very anxious to get this process going so that it would correct a number of what we feel to be deficiencies in the current charter. We are very much in favor of raising the threshold for the voting of disposal and lease and license of city-owned properties. We're very much in favor of closing the license lease loophole. And we're very much in favor of the transparency and that this would bring to the process. I did think that there was an excellent suggestion by Commissioner Herbst and seconded by the mayor that we should be thinking about thresholds, either in size or dollar value, because we don't want to tie up the commission in a number of things. So this is an expression of principle, and it can be worked on to be modified to efficient. '26. So we are anxious to work with you. We'll work with the council. We'll work with anybody to make this information available to the public so that they will have an opportunity to vote on this in November. Thank you very much.
Very good, thank you. And Barbara Stern.
Good afternoon, Barbara Stern, coming to speak on behalf of a couple of the items addressed from Charter Revision Board. Particularly Section 3 dealing with elections. One thing I'd like to point out is I believe Richard Weiss under the prior board had recommended that we do away with the commission being the final judge of, excuse me, not final, but being the judge of the qualifications subject to court approval, because in the end it's going to the court process anyway. So I'd like to go back to the 2022 elections, and let's just think if we really had politics involved. We had a phone call from the mayor's office encouraging somebody to not withdraw a challenge to the election. I would hate to see where that would go if this commission actually sat as the qualifier. If we had 3 people who didn't like someone who got elected, the 3 of you could remove somebody and take away the vote from the people and make that person file an appeal in the court system. Imagine if it had been one of the 3 of you, Ben or Commissioner Glassman or Mayor Trantalis, who were put in that position. How awkward and how uncomfortable that would be.
So who do you think that should be then? Who?
I think it should get rid of the commission being the qualifications and it just goes straight to the court process, because that is where it's going anyway. So why have a middle ground? That was Richard Weiss's opinion. He has written charters for various other cities, and that was his recommendation. And take politics out of it.
Yeah, I agree. I mean, I'm not comfortable with that. So I wasn't comfortable with it last time. So explain to me. Take me through the process as you would see it. Let's say there's a close election, or there's someone deems as unqualified to be eligible for the office. How does that process start?
So the process typically starts by you filing a lawsuit to stop that candidate from moving forward. You bring up your election challenges at that point, because once someone is elected, you're trying to take away and subvert the will of the people. And that's what the case law says. You bring it, and Vice Mayor Herbst brought this up, you bring the challenge before the election, so that the people's vote matters.
Who would have standing to do that?
It's typically someone who's actually running.
So just another candidate would be?
Another candidate has it, an elector has it. For instance, in Deerfield Beach, you had people that tried to step in, and that one, Chad Stevens felt that he was a candidate in that race. And what the court said is you needed to do this before the election.
All right. So if an elector, which means anyone who's registered to vote in the city, or another candidate who obviously is an elector. So any elector would have the standing to take that to court, but before the election.
Correct.
That's what you're recommending. Okay.
Correct, because afterwards you're just trying to take away the vote from the people.
Okay.
And the people's vote should stand, and that was raised. Also, I support taking away the affidavit requirement. What we saw this last go-around in 2022 was Alan, while I said we have to accept the affidavits, there was no process to determine legal sufficiency of them. We had affidavits that were not based upon personal knowledge. And then the people were upset that they actually had to come into commission and try to defend their positions and fight it themselves. They thought the city was just going to do the challenge for them, and that is not the appropriate process. And the affidavit provision should be removed, especially since there is no process to determine legal sufficiency and you're required to accept it.
Well, under your approach, though, that becomes almost a moot point.
Correct.
Right? Okay.
Correct.
Alrighty.
And then also in support of closing the licensing lease loophole, that was the workaround. People started doing these 99-year license agreements to bypass the leases. I know we've raised some concerns. We cannot compare to Bahia Mar. Bahia Mar has its own chapter. It's got its own regulations. Bahia Mar would not be a comparison. But if I recall properly, last summer, we had a project. It's where the old post office is, urban development market. I can't remember. But we voted, this commission voted, to give them a lease starting in, 2054 or something like that, to give them the additional time that they needed for a condo project. So we do have a mechanism in place, but changing it and bringing in the licensing would close that loophole so that we could bypass some of these deals that we've had that bypass the normal process.
Okay.
And I do actually agree with you, Mayor. You will find this to be very odd and out of line, but I do agree with you that I think 18 years old is a little bit too young to serve on the commission, especially even the mayor's position, given the important decisions that we make. If people want to be engaged,
Right.
Get on a committee or on a board. So thank you.
All right. Thank you. All right. Is there anyone else who wishes to speak on this item? Okay. There being none. How do we want to do this? Let's just jump to the CRA board meeting right now, so we get that out of the way. Is there anyone here on the CRA board meeting? It's sort of a quick thing, so let's just jump to that if we could, because we got a closed door session at 4:30. Okay. The CRA board meeting is now in session. Mr. Clerk, please call the roll.
Vice Chair Herbst. Commissioner Glassman.
Here.
Commissioner Beasley Pittman.
Here.
Commissioner Sorensen.
He's here.
And Chair Trentalis.
Here. M1, motion approving the minutes for the September 3rd, 2025 Community Redevelopment Agency Board meeting minutes. Someone like to move that item?
Moved.
Do I hear a second?
Second.
Moved and seconded. Please call the roll.
Commissioner Glassman.
Yes.
Commissioner Beasley Pittman.
Yes.
Commissioner Sorensen.
Yes.
Vice Chair Herbst.
Yes.
Chair Trentalis.
Yes, and M1 is now approved. R1 is a resolution approving a transfer between capital projects, Northwest Progresso Flagler Heights redevelopment area, and the Sistrunk Crosswalks project. Someone like to introduce the resolution?
Introduce.
Has it been introduced? Anyone have any questions? There being none, please call the roll.
A resolution of the Board of Commissioners of the Fort Lauderdale Community Redevelopment Agency approving a budget amendment and providing for an effective date. Commissioner Glassman?
Yes.
Commissioner Beasley Pittman?
Yes.
Commissioner Sorensen?
Yes.
Vice Chair Herbst?
Yes.
Chair Trentalis.
Yes, and R1 is now approved. Is there any further business of the CRA? There being none, that meeting is now concluded. Raquel, what do you want to do? Do you want to? Can we listen to your report?
Certainly. I think there's some length to some of the reports, so I don't know if you wanted to go through that before the closed door session.
Well, I know you have a number of items you want to discuss, which might take some time, so that's why I'm wondering if we should just go to the closed door session and then Well, then we're going to have our break, so we're going to have to do all that stuff after the evening meeting then. All right?
I'm open to
Okay, why don't
order.
we just do that? Does that make sense for everybody? Okay, we'll just do that. Okay, so the conference meeting is now suspended until after the evening meeting tonight, and we will now go into the closed door session. Do I have a speech? No.
Marilyn Romano's. If anyone knows. God bless them.
So at this time, the City Commission shall meet privately to conduct discussions between the City Manager, the City Attorney, and the City Commission relative to pending litigation pursuant to Section 286.011 parentheses 8 of the Florida statutes in connection with the following matters. Florida Department of Transportation versus the City of Fort Lauderdale, 4th District Court of Appeal, case number 4D as in David, 2025-2876. City of Fort Lauderdale versus Florida Department of Transportation, 4th District Court of Appeal, case number 4D, 2025-2783. And the City of Fort Lauderdale versus the Florida Department of Transportation, 17th Judicial Circuit, 17th Judicial Circuit of Florida, case number CACE 2501-4235, parens 03. And finally, the City of Fort Lauderdale versus Florida Department of Transportation, Florida Division of Administrative Hearings, case numbers 25-004856RU and 25-004820RU. Present at the attorney-client sessions will be myself, Mayor Dean Trentalis, Vice Mayor Commissioner John Herbst, Commissioner Steve Glassman, Commissioner Pamela Beasley Pittman, Commissioner Ben Sorensen, City Manager Raquel Williams, Interim City Attorney Dwayne M. Spence, Senior Assistant City Attorney Paul Bangel, Assistant City Attorney Kimberly Cunningham Mosley, Outside Counsel Howard D. Dubosar, Esquire from Waisorota, Outside Counsel Jeremy Rosner of Waisorota, and Certified Court Reporter from Bailey Enton Court Reporting. The estimated length of the session will be 15 minutes for each item for a total length of time of 1 hour. Let us now retire to, where are we going? To the green room?
The green room.
Yeah, you access it through the Einstein room.
I'm sorry?
You access it through the Einstein room.
Yeah.